I'm the principal of Chryson. We are a construction and engineering law firm based here in Sydney in the CBD. On behalf of our firm, it's a pleasure to welcome you here tonight to the Pafburn and the Afterburn, a masterclass dedicated to unpacking a very impactful legal development for the construction industry with the recent decision of the High Court. We're very grateful that you could join us after hours. The fact that you are here as industry leaders, developers, contractors, legal professionals, consultants and decision makers gathered here tonight speaks volumes about the relevance and urgency of what we'll be discussing tonight. So why this event and why now? When the High Court handed down the Pafburn decision recently, it didn't just clarify a point of law, it actually challenged the way that we think about responsibility and the roles that we all need to play in the life cycle of construction projects. As a result of Pafburn, contracts need to be reassessed, professional advice is being sought about liability is being recalibrated, and so it's a lot more than just about compliance. Pafburn actually introduces a need to change the way that we think. It's an opportunity to shift from reactive adjustments to proactive transformation. Pafburn challenges us in the industry to consider how responsibility is to be shared across a project team and how that responsibility needs to be looked at in the context of the entire life cycle of a project from conception until potentially 15 years past completion. This masterclass was curated not to only explore the ripple effects of that decision, but to ask how as an industry we can respond constructively and how to turn the disruption of Pafburn into leadership and economic and business sustainability. Our goal tonight is simple but significant. It's to provide clarity, to provoke meaningful thought, and to equip you with insight that can potentially translate into action. You'll hear from the sharpest minds, or some of the sharpest minds across the building and construction and legal sectors. We have the privilege of having counsel from the Pafburn decision present with us tonight, David Weinberger and Tony DiFrancesco. We have the privilege of having David Chandler, who will be speaking to us, former building commissioner, and George Zakos, a building consultant. And you'll be guided through practical implications of the decision, and you'll be asked to consider strategic implications, and we encourage you to engage with questions. There will be a panel, and that panel will be very informative, and it will be very interesting. And in our private discussions with our speakers, there are very interesting opinions and positions, and some of them may be different. The session reflects Chryson's broader commitment to thought leadership and to support professionals with tools and perspectives to navigate the complexities of what Pafburn means with confidence. I trust that you've all collected your compendium that was handed or available to be collected at the time that you arrived. In the compendium, you will find a number of bios of our speakers. You'll also find the agenda, and there's also a sheet here called Pafburn and the Future of Construction Law in New South Wales. There is a QR code in that document. That QR code will lead you to resources. It will lead you to a resource page that will introduce you and which we want to share with you some of the learnings of the decision. It will be a good opportunity for you to have a look at that. We hope that the takeaway will be that you will have a new lens for assessing your contracts and your professional and statutory duties, a deeper appreciation of how risk can be reframed as a strategic asset, and above all, the inspiration to actually be a change maker in your own space, whether it's a builder, consultant, developer, or legal advisor. Pafburn is a line in the sand, and what we do and what you do as construction professionals will define not just compliance, but culture and sustainable business opportunities. To help guide us through the night, Richard Couture is going to be our moderator. I'd like to introduce Richard to you. Richard brings a unique perspective to the room, not just as a seasoned and strategic advisor, but as someone who's deeply engaged in conversations shaping our industry right now. He has authored a number of ebooks on building reforms and the Pafburn decision, which you can access through the QR code. And Richard breaks down complex regulatory legal changes into clear, accessible insights for professionals across the sector. He's also the voice behind the recent podcasts that we have been sharing in social media. And Richard's strength lies in his ability to translate big changes into practical direction, and he knows how to move between legal frameworks and the real-world pressures of timelines, budgets, and stakeholder expectations. Richard, I'd like to now invite you to the rostrum, and thank you, everyone, for participating tonight. And I've just done something that I shouldn't have done. So if somebody can assist that knows how.
Thanks, David. That was very nice of you. Ladies and gentlemen, thank you very much for coming. Welcome, and thank you for joining us today for this important event, the masterclass, we'd like to call it, on the Pafburn decision and what it actually means for everybody involved in the construction industry. Since the Design and Building Practitioners Act came into being, some people call it the DBPA, we've seen a significant shift in the way that projects are delivered, in the way that there's responsibility for who carries out legal risk or who carries the legal risk in relation to those projects. The recent Pafburn case decided by the High Court has only sharpened our focus in relation to that responsibility, and this is what the talk tonight is about. If you're a developer, a builder, or even a financier or an insurer, actually, or anyone involved in the delivery of construction projects and the oversight of construction, the decision directly impacts you, or it may directly or indirectly impact you. In simple terms, the court has confirmed that even if you subcontracted the whole of your works away to other people, to subcontractors, it's quite possible that you'll be made 100% liable for the defects that they've actually caused. This makes it absolutely critical, actually, to rethink the way that projects are procured, risk managed, and the way that the contracts are, in effect, protected. Not just at the construction phase, but across the entire life cycle, as David did mention, from the design stage all the way through to 10 years after the completion of the project's Environmental Planning and Assessment Act. But here's the real message, I think, that we hope to share with you tonight. Pafburn is not just about risk, it's about what I think of as an opportunity from a commercial or economic perspective. Those who adapt quickly by strengthening their systems, improving quality control, and managing compliance, optimizing their supply chains, may be able to avoid the legal pitfalls. It's not always possible because you can get sued for the work that you're responsible for, but if you undertake some of the steps that we envisage will be crucial in dealing with the current status quo, you may be in a position to become really industry leaders or gain at least a competitive advantage. The people that take that opportunity may be better able to deliver projects, attract stronger partners, and develop their prospects. In fact, they can protect their reputations, because we've seen that a lot of these DBPA cases can cause a lot of damage to people's reputations, unfortunately. And also, you may have access to better insurance and financing conditions and options. And that is very important as well in the current milieu. In a world where public confidence in construction is critical, and I do point to the High Court decision, actually they refer to collective responsibility. They use that phrase, which is really important, I thought, because both the majority judgment used it and the minority opinion used the same concept as well. And it's interesting that they arrived at different results using the same kind of starting position. But if public confidence is taken at face value, the Pafburn result might actually provide a clear incentive for smart businesses to step up and distinguish themselves. Today you'll hear from some of the country's respected legal minds, industry experts and strategic advisors and thinkers about what the Pafburn decision actually means, the risks you must now manage, how to turn regulatory compliance into a source of commercial strength, hopefully, and the practical steps you might need to take in order to secure your projects by future-proofing them and by hopefully making as much profit as possible. The consequence, of course, is, as I mentioned before, is economic. That's why this masterclass is not just a legal gathering or a legal conference. It is aimed at optimizing your business in light of the decision. Basically, conserving your hard-earned money in the compliance side of things on the one hand, and trying to make you competitive on the quality side and the work side on the other. The masterclass is, and what follows is, I think, a blueprint for resilience and opportunity, hopefully, for many of you. So let's get started.
Thank you. Thanks for that exaggerated introduction. I'm going to speak for 20 minutes, and what I propose is I'll talk for 15 and then I'll field some questions. I don't have a script, but I have an idea of what I want to say. What I want to start with is introduce the pathway to this legislation. What triggered the need for this legislation? And that is whether a builder or a developer or a subcontractor owed, for example, a subsequent purchaser a duty of care. So if you're a developer, subcontractor or a builder, you construct a block of apartments, all the apartments are then sold, and say the owner's corporation or just an individual suffers loss and damage due to defective construction or design, whatever the case might be. The legal position generally was that the builder did not owe a duty of care to the subsequent purchase. I'm putting it at a very general level. There were some exceptions, but that was the starting point, whether you're an engineer or a designer. So it became very difficult for plaintiffs to have any confidence in being able to sue a builder, developer or a designer unless they actually had a contractual relationship with the builder. So along comes this legislation, and it effectively provides that if you carry out construction work, and to put it generally, I'm not going to be overly technical, there are defects, you owe a duty of care if you carry out construction work. Now, what is construction work? It's a very broad definition. Some aspects are easily conceived, others are a little bit tricky. Now, if you're a builder or a subcontractor, you carry out construction work because that's building work, and that's quite obvious. And then there are other specific nominated examples of construction work, whether it's carrying out designs or providing materials. So if you're a supplier of cladding or pipes, two quite common defects in the last few years, you owe a duty of care because that's carrying out construction work. And then there's another limb to the definition of construction work, which is somewhat unclear and very broad. And that is this: if you're involved in supervising, coordinating, project managing, any of the above, for example, building work, you're carrying out construction work. And moreover, If you have substantive control over the carrying out of building work, you're carrying out construction work. Now, what substantive control actually means is not yet known, and the precise ambit of having control over building work is not yet known. Let me give you an example or two. If you're a developer, do you exercise substantive control over carrying out the building work? You enter into a contract, typically. You're removed from day-to-day operations, how the waterproofing is carried out, or the actual building. So do you owe a duty of care in those circumstances? On one view, you don't. And even if you did, what's the ambit or extent of that duty? You don't have a duty to inspect as a developer all of the work that's carried out. But what if, like in this case, in the Pafburn case, you're the builder and the developer, albeit wearing two different hats? What happens in those circumstances? Could be far more complicated, because if you're the director of the builder and the developer and you walk onto site supervising the work, a court might find that you did that not only in your capacity as a builder, but in your capacity as the developer. And it gets even more complicated than that. If you're a building certifier, a private certifier, or a council inspecting the work, and from time to time, as we know, in relation to residential buildings, certifiers have to carry out mandatory critical stage inspections, and we know the certifiers or council issue occupation certificates, typically stating the building is suitable for habitation. Now, do certifiers carry out building work? And I'm putting that in the rhetorical because it's unclear. That the High Court said arguably not, didn't determine it. And the way I read the High Court decision as saying arguably not is because the certifier doesn't actually exercise control of do it this way, do it that way, how the work should be carried out. They have a look, they inspect, and they issue a certificate, or they don't. Post the High Court decision, Justice Hammerschlag had occasion to consider the question, and he took a slightly nuanced and different view. He said you've got to look at it on a defect by defect basis. You can't look at it at the hypothetical. In other words, if the certifier comes onto site, this is my interpretation, if the certifier comes onto site and says, I'm not going to certify that because you haven't done this, that and the other, and until you do this and that and the other, I'm not going to issue a certificate, that might be exercising control. But even then, one has to, there's a question, you have the duty, and then it's a question of whether there's been a breach. And this is, I think this is one area I've seen where there's some, won't say confusion, but lack of clarity amongst at least some of the lawyers. So all you have to do is exercise reasonable care. It's not like the statutory warranties where if you're a builder, you've got to produce a product or a building that's fit for purpose, come what may, even if you weren't negligent or if you're a developer and you engage the best builder in town. You've got to be negligent. Now, as a builder or a subcontractor, if the work is defective, in my view, that bespeaks of negligence. You haven't done it properly. But what if you're dealing with defective materials? You're the builder or the subcontractor, and you purchase, whether it's paint or cladding or pipes that you think, or everyone in the industry thinks or assumes is fit and appropriate. In those circumstances, it's difficult, taking that simple example, it's difficult to see how you could be held to have been negligent. Similarly, if you're a builder or subcontractor and you're following a design, and the design happens to be a dud design, again, there'll be difficulties in proving that you were negligent. So that's what I want to really say about what this legislation has introduced, the negligence test. If you have anything to do with a building site, you've got a duty of care, but if someone sues you, they still have to prove you were negligent. That's the starting point. The next aspect is really what was the subject of the High Court case, and that is this legislation says the duty is non-delegable. Now typically that means you can't give it to someone else to discharge that duty. And under the Civil Liability Act, which also applies when you're sued, or you could say, for example, well, someone else is 50% liable or someone else is 80% liable. So a certifier, if sued, would ordinarily say, I might have missed a bit of this or that, but the builder is 90% liable. So the High Court said that because the duty is non-delegable, you as the builder or subcontractor, whoever the case might be, you can no longer say it's really mostly or partially someone else's fault. It's really the onus is entirely on you, and if you rely on someone else, so if you're a builder and you engage a subcontractor, that doesn't let you off the hook. You've got to basically make sure the subcontractor does the work properly. Now, where a developer can come unstuck here, although I've said generally, if a developer has a duty, because there's a question of whether they're exercising substantive control, and they're not there every day, mostly looking at how every brick is laid and how all the waterproofing is done. But where a developer can come unstuck under this legislation is, let me give you this example, and it's one, I've got a case on this point, so it's appropriate. A developer has a choice as to how they carry out bulk excavation, right, in order to build a two-storey car park. They can take, I'll just describe it as the cheap option, which has some risks, or they can take the Rolls-Royce approach, that is far more expensive. The developer, or this particular developer, takes the cheaper approach. And as you can imagine, this causes loss of support to the adjacent building, cracks, all sorts of problems. So in those circumstances, it could well be argued, in fact it could be argued, that the developer exercised control as to how the work was carried out. The developer had a duty of care, should have, so the argument would go, should have chosen the Rolls-Royce approach to make sure next door didn't collapse. Collapse is an exaggeration, but you get my point. So in those circumstances where a developer can no longer say, well, I just gave it to the builder and I'm off the hook. The developer has to take reasonable care in the choices it makes as to how the work is carried out. And that might extend to, for example, if a developer chooses to engage a subcontractor or a head contractor who might not have sufficient experience in a particular type of construction, and that causes defects. That could also be an example of where a developer has failed to exercise reasonable care. And a lot of time was spent in this Pafburn decision, was returning to the primary point as to what was meant by the non-delegability of the duty. So it seems as though there is still scope to argue that if you were sued, you can still apportion liability to another party as long as you're not suggesting that you delegated that task to the other party, right? So if you're a certifier that's sued, assuming you're a certifier that can be sued, a certifier couldn't say, well, I delegated my certification role to the waterproofer, and therefore in those circumstances a certifier may still, subject to one matter I'll come to, may still be able to assert proportionate liability to say, well, I'm only 10% liable and the waterproofer's 90% liable. But if you're suing a builder and the builder is delegating or entrusting the work to the electrician, the plumber, the subcontractor, etc., the builder can't say, well, go sue all these subcontractors. And I think practically it makes, this sort of legislation makes sense, because if you're an owner's corporation or a homeowner that's simply bought a house that's a few years old, you don't want to be in the position where you have to sue all and sundry, everyone who touched or sniffed the building site, in order to recover what your loss is. So practically I can see why the court, albeit by majority, took the view that this legislation should be interpreted as not permitting a builder, for example, to say to a plaintiff, go sue everyone else. It would just be unwieldy and extremely expensive. Then there's also the other question of, and I touched upon it earlier, but I want to return to it. If you're a director, right, of a developer, say, for example, and you go to site and you have a sense that, or for whatever reason, you know there's reason to believe that the design may not be up to scratch or the work may not be carried out properly, you can't just walk away and say, well, I left it to the builder or I left it to the engineer. You've got a positive duty to exercise reasonable care, but assuming you have the contractual power to stop the work or influence the manner in which the work was carried out. So that's in a nutshell the effect of the decision, and the one caveat to what I've said is, I said earlier, there may be scope to argue proportionate liability if you're not blaming someone who you delegated the work to. But that is this: the Court of Appeal found that the Civil Liability Act had been repealed, implicitly repealed, and therefore didn't apply at all, and therefore you couldn't have apportionment. The High Court, although in this case reached the conclusion which it did so via a different pathway. So there's still a question alive in my view as to whether apportionment at all applies or can apply for the purposes of this legislation. And I was in fact scheduled to run that argument Friday week, but it's gone away, at least for now. So that's all I want to say about the nature of the decision, but I'd love to field some questions if anyone has any. Someone.
Is this all still in the Class 2 space, or do you think this Act could be extended to include Class 1?
All work. So there's no limitation. It's just if you carry out build construction work as defined, you've got that responsibility.
Has there been a Class 1?
I think there has been one. I can't recall if it was fully argued. It might have been a case called Godwin, actually. Yeah, Goodwin, that's it. Yeah. It's coming back to me, yes.
Goodwin Street project.
That's it, yeah. That's the one. Yeah.
You started by saying that the intent of the Pafburn arises from a certain series of events in the Design Building Practitioners Act. And when you look at the second reading speech, there's a focus on all building professions. And the legislation is called Design Building Practitioners Act. And Parliament said designers, engineers, architects, builders, all need to be held to account. So, and then on the other hand, the legislation has a non-delegable duty to developers and builders. So it seems to me that there's sort of a disconnect between the intention through the second reading speech, where the focus was on designers and builders, and now suddenly designers are off the hook, if you like. And I'm not sure if I agree with that, because designers are the ones that hold the expertise in the design space. So I'm just wondering what your thoughts are on that.
Designers are on the hook because construction work has a four-tiered definition. It's you're doing the building work, or you're carrying out regular designs, or you're supplying materials or products, and the final catch-all is supervising or exercising control, or substantive control, again, whatever that might mean. So, and I say that because it hasn't been determined. So they are all court, and each of them have a non-delegable duty. It's difficult to see how a designer or supplier of materials could delegate whatever it is they've been entrusted to do. I one might manufacture examples, but practically it seems difficult. But the real question would arise typically where you're carrying out either building work or you're supervising or exercising control over the work. Yep, at the back.
Hi, sorry. I'm calling from Assaline Capital. So we're a financier. We implement something called active lending, where we sort of oversee or a bit more control over our construction loans. And obviously, like you said, it sort of says that people who have control, would you consider a financier who sort of project manage, not really project manage, but like oversees the development?
You know, that's a very good question, because I imagine you'd send your not just your QS out every time there's a drawdown or progress claim to see if the but that's mostly to do with quantities, and I don't think that's really exercising control on how the work is carried out, or you're not getting to the point where you are. The question may arise if you're refusing to, for example, draw down or pay a progress claim on a construction loan if you take the view the work is defective. Or if you're a mortgagee in possession and the building is defective, or you then complete the project as the mortgagee in possession, in those circumstances you could get into the sphere where you've got a duty to take reasonable care. But it would be difficult, I imagine, to prove, using my vanilla examples, that you've breached that duty, because what would you be doing? You'd be engaging other experts as the financier. Asset line, you said, right?
Correct.
Yes, sitting in your office in Bondi Junction, making sure, or entrusting them to do the work. So I think it would be difficult. If I can imagine a factual situation where it could be argued you are, but you'd have to be really getting into the nuts and bolts of the construction before it could be said that you breached your duty. A, that you exercise control, i.e. that you owed a duty, first stage. Second stage, that you breached the duty. And to the extent you breached it, you'd only be responsible for the defects the subject of your breach, not automatically every defect associated with the construction.
Thank you.
Would it still carry through to retirement villages, a lot of which are done by NGOs, who palm off a lot of, basically try to hand the entire control of the building to the builder, but still retain a lot of control with the design and the running of the design? I'm talking church groups here, but
it's like really any developer, but generally most developers, you know, they might engage an engineer or an architect, and they just assume appropriately that the design is compliant, whether with the BCA engineering standards, whatever the case might be. It's not the developer's role to peer review every design that's produced.
unless they choose to.
And even if if they peer review it, then if there is a duty, they certainly have discharged it, because they're getting I would argue, because they're getting a second opinion to say everything's fine. Question might arise if the second opinion says there's a problem, or there might be a problem. So in some ways, the less you do, the better. Anything else before I sit down? Okay. Thanks all.
Good evening, everybody. This is a piece of legislation that has caused a lot of debate in our industry, and it's caused a lot of division as to whether it's a good thing or a bad thing. It's even caused division of opinion in cases as to how you even interpret this legislation. Pafburn, for example, there were single judges of the Supreme Court who had decisions that said proportionate liability applied to liability under Part 4 of the Design and Building Practitioners Act. There was the Court of Appeal that said 3 judges to 0, proportionate liability didn't apply. And then you go to the High Court and you have 7 of the highest judges in this land split. And the majority was 4 and the dissenting minority were 3. So one judge seeing it differently, this would have been a whole different talk today. Unfortunately, or fortunately, depending on how you look at it, there is a paradigm shift in how liability is going to be placed onto people involved in the building and construction industry, and people who maybe see themselves as only sitting on the periphery and wouldn't normally expect themselves to be liable. Now, that's half a glass of water, and you can see that as half full or you can see it as half empty. So you can see this as an opportunity or you can see this as a burden. However you look at it, the reality is you need to contemplate what it means for you, and you need to contemplate how to manage risk so that at least you can minimise the downside to this, and perhaps in your own way use it as a justification for improving things. It happens from time to time that governments will implement legislation which is very harsh to one person because they're trying to be very kind to another person. And that's a value judgment that our politicians will make. Sometimes, in an effort to achieve a very good cause, they will cause a lot of pain to other people. I mean, some examples that you might remember might be, for example, the live cattle trade bans that have happened, and the live sheep trade bans that are happening. Now, a lot of people in this room might say that's an absolutely excellent thing because it's going to stop cruelty to animals. Other people might say, how do you take someone's livelihood who's been doing this for generations and just say to them, go find another market and maybe drink a cup of cement and toughen up. Some of you will look at this legislation and feel like the poor farmer who says, I've done this for generations, what have I done wrong? But for better or for worse, that's the legislation we have to deal with. And so we need to consider its scope. David has taken you through many aspects of the scope. And when we talk about the legislation, what I'm focusing on is Part 4 of the Design and Building Practitioners Act, which creates this duty of care that Pafburn was looking at. While I won't go into it, it is important to bear in mind that the Act has many other aspects to it. It, for example, regulates designs and approvals that need to be obtained for those designs. It also sets in place criminal provisions, which are easily overlooked, about complying with design obligations and carrying out work properly. Something for people to contemplate is whether those other provisions outside of Part 4 perhaps also might give rise to liability in a civil way. So Part 4 of the Design Building Practitioners Act creates this duty of care. Some other parts of the Act on designers, on engineers potentially, on people who carry out building work, to carry out work with due care and skill, or if they contract to do it, to make sure whatever they've contracted to do is done with due care and skill, and if you don't, there might be some criminal consequences. Well, it may flow from that, perhaps, that there will be something called the tort of breach of statutory duty, that the courts might say that that criminal provision or that prohibition is also intended to give rise to a civil right for somebody who suffered loss from a breach of it to sue. Now, at the moment, I'm not aware of anyone pleading that or trying that, and maybe you don't need to because we have Part 4, but it is something to think about. and it just shows you the sort of challenges that this legislation throws up. And they're easily overlooked because at the moment we're all focusing on Pafburn, but there's a whole raft of other sections out there waiting to be discovered. In relation to the scope of the duty of care in Part 4, we have this Section 36 of the legislation which sets out the definition of construction work. That is important because the duty of care in Section 37 applies to a person. Stopping there for a moment, a person is a very broad concept in legislation. A person is not just a human being, but it can include a company, it can include some other incorporated entity. But what you all need to think about is it includes people. So that is opening up a can of worms potentially that we'll come to in a moment, talking about breaching the corporate veil. Now, the duty is a person who carries out construction work has a duty to exercise reasonable care. Now, as David said, it's not a duty that if there's a defect you're liable automatically. It's not like the Home Building Act where you have a contractual warranty to make sure the work is up to scratch and that the thing you've built does what it's supposed to do. You have to exercise reasonable care, so it's not a blanket guarantee, and it's reasonable care to avoid economic loss caused by defects in or related to a building, and building is in Section 36 very broad, it's not just residential work, a building for which the work is done and arising from the construction work. Now, dealing firstly with this issue of what is construction work, in Section 36 of the Act, construction work includes building work, which has its own definition, but for today's purposes, let's just say it's building something, it's hammering in nails, it's putting in formwork, it's pouring concrete, it's that sort of thing, the physical things you do. And then it's also preparation of regulated designs and other designs, which is the question from the front row that came up with David. It's also the manufacture or supply of a building product used for building work. So if you're supplying materials, if you're supplying sinks, if you're supplying taps, that's something you're supplying. There's a reasonable care to be exercised, but also the manufacturer has a duty. Reverb. Sorry. Sorry, we just had a wardrobe malfunction there. So manufacturers conceivably have a duty of care here. So say, for example, you're a company in China manufacturing some building product, or you're in Germany manufacturing a sink. You may not realise it, but you've got a duty of care here. Maybe that's how far this thing goes. More relevantly to us, perhaps, say, for example, you've got a factory here where you manufacture precast walls or precast forms for pouring concrete. Well, arguably, you've got a duty of care because you're a manufacturer. And you've got that duty of care to some person you may never meet. You know? And then 5 years down the track, you're getting sued by, for example, an owners' corporation. But that may be a good thing because it gives owners rights to deal with defective materials. But it just also shows how broad the net is being cast here to capture people. And then the last one, which is the very controversial aspect of construction work, is supervising, coordinating. If you think about it, that's broad ideas. Project managing. In construction, that tends to have a more focused idea of what project managing is. Or otherwise having substantive control over the carrying out of any work referred to in A, B or C. So basically the carrying out of physical building work, preparation of designs, manufacture or supply of building products. Now we don't know yet exactly what is substantive control because there's going to still be plenty of argument about that in the courts. But we know from some of the litigation that's happened so far, including one of the earlier decisions in Pafburn that was not part of what went to the High Court, that it is said that supervising, coordinating and project managing are things that you actually do. You actually supervise. But having substantive control is said to be something broader than that, in that it captures both actual control of the work, something that you physically do, but it also captures if somebody has the capacity or ability to exercise control, even if they sit in their chair and do nothing. So if you've got the ability to do it and you omitted to do it, you can still be negligent. In fact, the whole sitting there doing nothing may be the act of negligence. You have to get out of your chair, you have to do something. Now, what is having control over the work? It's a debatable proposition, but if we look at the situation of a developer, for example, in Pafburn, the majority decision at section 56, paragraph 56, talked about the duty of care that would be owed by the developer, Madarina, and the head builder, Pafburn. And the court said this: within the framework established by Section 5Q of the Civil Liability Act, and I'm not going to go into all that today, it gets a bit technical, I'll just try and keep it simple. And on the contentions of the Owners Corporation, so stopping there, the case as set out by the Owners Corporation, the allegations they made, which were particular, as David referenced, it was where you had related companies in that the developer, oddly enough, was a subsidiary of the head builder and they had common directors. And David's client pleaded that that relationship was, including that the common director of both the builder and developer was also a licensed builder, nominated supervisor of the head builder, etc. So that was the context of the pleaded case. But the court said this, and what David's client said is because of that structure, the developer had substantive control or the ability to control or actually controlled, depending on how the facts were going to turn out, over the work that was done by the head builder. So that's the context, and what the court says is, within the framework established by Section 5Q and on the contentions of the Owners Corporation, A, Madarina as developer delegated or otherwise entrusted to Pafburn the construction of the building, and in so doing supervised, etc., so supervised, coordinated, project managed and otherwise had substantive control over the whole of that construction work. And then it says and B, Pafburn as head building contractor constructed the whole of the building and in so doing delegated or otherwise entrusted many kinds of construction work to others. Now, you could read that paragraph narrowly or you might read it a bit more broadly. If you read it narrowly, you'd say, oh, the High Court's only saying in the way that the case was put in Pafburn, the developer owed a duty of care because in that unusual structure, the developer had substantive control. But if you read it more broadly, what it might be saying is that the developer set out to build the building. So the developer, for example, runs around marketing, this is my building, I built this building, I developed this building, my building. Then what does the developer do? It either, in one sense, delegates, or in the much broader concept that the majority of the High Court looked at, entrusted. It entrusts the work to the builder. Now, if you put it in those broad terms, the developer is building the building, but it then gets somebody else to do the work for it. And if it's as broad as that, developer's on the hook. That is a paradigm shift. That is very different to anything we've seen before. And if it is what I've just said, how do you distinguish a developer from a homeowner? Mum and dad decide they want to renovate their house. Mum and dad decide they're going to knock down the old fibro cottage and they're going to put up a nice new house. Are they building the building? They're not an owner builder perhaps, but is it their building? If they're an owner builder, it's even clearer. But imagine they're not an owner builder, are they? Are they having substantive control? And you might say, no, that's ridiculous, they're not. Well, what about this proposition? I'm a developer and I pay the bills. And when I pay the bills, I get my QS to go out, or I get my project manager, or I take a risk and don't get any of that. I have the capacity and ability, but I don't exercise it. I sit in my chair. And I have the ability to say, I will not pay this bill because this work is incomplete, that work is defective. And until you do what I say, I'm not paying that bill. Is that substantive control? Is that the ability to get work done? We don't know. Then what about this? I'm a developer and I have a building contract that says I have a defects rectification period. And I have the power to tell the builder, go fix that for me. Does that give me substantive control? If I say to the builder, I'm not worried about defects, I'm going to sell this to some mug and I'm going to disappear, that sounds very evil and everyone wants to get that developer. But what if I'm just a normal developer and I look for defects, or I hire a QS to look for defects, and remember this duty is non-delegable, so if I give it to my QS, I'm still responsible for what that QS does. And we miss something. Someone might say, well, you exercise reasonable care, you'll be safe. Well, what is reasonable care? What if I exercise my care and I miss it because I had a bad day, or I'm under the weather, or I just make a very human mistake? In that scenario, I have failed to exercise reasonable care, I've missed a defect, I had the ability to push the builder to fix it, I didn't do that. Am I now liable for that defect? I think the answer is yes. So in my mind, where it's at is we have broad legislation. Some might say draconian, others might say a breath of fresh air, depends which side of the fence you're on. And we have the position that it may capture a whole heap of people who just aren't used to thinking in these terms, or it may not, we don't know because the courts haven't decided it yet. But in my mind, what it needs is for the legislature to look at this legislation and say, hold on a second guys, in our effort to stop the bad press about Mascot Towers and Opal Towers, we might have jumped the gun a bit and we better think about how to put this genie back in the box. And I think there needs to be a lot of lobbying to get that done, and you guys will have some ability to lobby and you should consider doing that. I think lobbying to remove the legislation is a waste of time. I think this thing is here to stay. I think just practically speaking it just is. But what might work is trying to say to the legislature, we just need to find a better balance. Now, coming back to this idea of you have these politicians that put in this draconian legislation to stop the bad press. Someone once said to me in a case I was in, and said it to the press in a case I was in, involving the super trawler. You might remember back in about 2010, there was the super trawler coming to Australia. Well, I was acting for the company that had the fishing quota and was bringing the super trawler out. And they went through all the regulatory things that they needed to go to. Peter Garrett, the Environment Minister, said, yes, this is all good. And once again, when I'm talking about this sort of thing, there'll be people who say, this is very bad, you're going to kill all the fish. And fishing's not a popular thing in a lot of places, for what it's worth. But it's an important thing because it's feeding people. Anyway, this was a very responsible entity. It had a lot of experience with fishing for mackerel and other pelagic fish. And there was a lot of science that said that having a super trawler, as long as it sticks to quota, if it doesn't stick to quota and just fishes everything out, that's a different thing. But as long as it sticks to quota, it's actually more efficient than having lots of boats. And there's a whole science behind that. And the government said, yes, that's fine. Then the press got into it and said, this is very bad, you're going to kill all the fish in the ocean. So let's import fish from other countries that have no restrictions and say that we're very good. And so the government turned around with the bad press and just banned the super trawler. No compensation, banned. That looks a lot like what they did here. Because even in the second reading speech, they talk about Mascot Towers and Opal Towers. They also talk about they're legislating to overcome a decision of the High Court in Brookfield. But Brookfield was in 2014, and this legislation was in the Parliament in 2019. Seems a bit slow. So I think you should be putting pressure on politicians to say, come on, we have to make this work for everybody. In the super trawler case, what was said in an interview in that case was this. The most dangerous place to be standing today in Australia is between Tony Burke and a vote. This has a feel of that. It's between the government of the day and a vote. And what they don't reflect, for what it's worth, is that Opal Towers and Mascot Towers were not built out of thin air. There was a government process that approved it. There was certification that approved work. There was a whole series of things that had to happen. And like a magician, don't focus on what the government did, just focus on this hand. And now we've solved the problem, we've made the stories go away. I'm not here to talk too much politics, and people will differ on these things, but what I'm trying to do is encourage you, to the extent you can, as developers and significant builders, and just the citizens, to lobby to try and get some clarity to this legislation. I mean, another way that this legislation lacks clarity, I would say, is the issue of apportionment. So Pafburn was dealing with the situation in front of the court. Pafburn was dealing with potential liability of a developer and builder. And it said, looking at that, you guys are delegating the building of the whole project, so you're liable for everything everybody does. If I put it into simple terms, that's basically what I think the court was saying. But Justice Gordon, during the debate in the High Court, pointed out that the process of construction and the process of duties of care under this legislation is not just top-down, it is bottom-up and it is side-to-side. Now, what did Her Honour mean by that? Well, I'll give you an example of top-down. Top-down is developer goes to head builder and then everything else goes down from there with subcontracts. Side-to-side is I might have a manufacturer who supplies some materials, or I might have perhaps a private certifier who comes in. Now that's very controversial because we don't know whether private certifiers are caught by this. There's a whole controversy about that, but I'm just saying it's an example of sides. Another one that might be sideways is engineers. And then bottom up is I have a subcontract tiler. That person is only doing the tiling. And above them, there's a subcontract tiler, there's a head contractor, and there's a developer. Now, we know if you're responsible for doing work, what the High Court tells us in paragraph 52 of the decision is that basically you're only responsible for your bit. So what the High Court says, and I'll just digress to read this, this duty of care under section 37(1) extends to all defects in or related to that part of the building sorry, I'll go back a step. So it says this at paragraph 52. The scope of the duty in section 37(1) extends to all defects in or related to that building arising from all construction work in relation to the building, whether or not the person in fact performed any of the physical acts comprising that construction work. In the case of a person who supervises, etc., so supervise, coordinate, project manage, or otherwise have substantive control, work for part of, so a person who does that for part of a building, such as the foundations, the scope of section 37 extends to all defects in or related to that part of the building, i.e. the foundations, arising from all such construction work. In the case of a person who undertakes only a specific type of building work, such as plumbing, the scope of the duty extends to all defects in or related to the building arising from that construction work, i.e. the plumbing. By the operation of section 39 of the Design Building Practitioners Act, within their scope, all these duties are non-delegable. So they're saying you're only liable for your bit. Now, with developer and builder, it's easy because their bit is every bit. That's the idea. With the tiler, their bit is just the tiling, for example. Now, if the tiler doesn't delegate to anybody, so say for example, I'm getting my screed done, I'm putting my tiles on, I'm making sure it's all level, I haven't delegated to anybody, I did that. Why can't I apportion? Say for example, I just did my bit and the foreman on site didn't measure properly, and I didn't measure properly and the fall was wrong. Someone might say that tiler is stuck with it because they can't delegate the measure of the fall to the site supervisor. But there's an argument that's still out there waiting to be decided as to whether that person can apportion because they haven't delegated to anybody, they've done it themselves. And if there's other people who've done things, they can get away with only being responsible for a part of the loss and damage, and other people will be responsible for their bits. There's a lot of uncertainty about that. And there's another view that's been expressed, which is if there's people I didn't delegate to, but I did delegate to somebody, then I can't apportion at all. But if you're looking from bottom up, it's hard to see exactly how that fits. So the courts will ultimately sort that out, but that's another thing that Parliament has left up in the air, and the Pafburn decision doesn't resolve. I'm not saying it should have resolved it, because it was just looking at developer and builder, but what I'm trying to say to you is there's a whole heap of uncertainty out there that still needs to be resolved, and it probably would be better if Parliament fixed it up than leaving it to a piecemeal basis of the courts having to deal with a case as and when it happens, and everybody else is waiting there going, I don't know, I hope it's okay. Now, I know time's against me, so I'm just going to make some very short points which are practical points that I just want people to think about. And so I've been talking about a lot of theory and where the Act goes. I think I should offer you some practical steps because you want to know what you can do day to day. So first thing I would say is you need to consider the sufficiency of your insurance. Are you covered, A, sufficiently as to amount, and B, as to the scope of the cover? So say, for example, I'm a director of a company and I have the capacity, I'm a head builder or I'm a developer and I'm the director of the company, I'm the big cheese, and I can get this company to do anything I want it to do. Well, potentially I've got substantive control over the work, and there's a recent decision called CASI where there was a builder company which had a sole director who was both sole director and nominated supervisor and was actually doing a bit of the work. That director was held liable. The legislation pierced the corporate veil, and not only was the building company liable, but the director was personally liable. You need to ask yourself, if you're in that position, does my directors and officers insurance cover me for this kind of liability? I have a feeling it probably doesn't. And you need to check it. The other thing is you have to ask yourself, do I even have directors and officers liability? Because maybe I didn't bother, but maybe I should bother now. Then also, you need to consider whether you've got in place sufficient insurance for your staff. Because say, for example, I'm a foreman. Say, for example, I'm in my 20s or I'm 19 years old. We've seen that before. 19-year-old foreman and things go wrong. We've seen that. And it had terrible consequences when scaffolding fell on that poor fellow and killed him. Right? But let's say I get some young person, or even I get any person, and they are hands-on and they're the foreman and they're doing all this great work and they make a mistake. Technically, you can sue them because they're carrying out the work. They've got substantive control. Now, you might say, well, they're an employee, they can just get an indemnity from their employer. Well, what if their employer goes bust? So you're going to have this person and they're going to be in it on their own, and you might say, I don't care, or you might say, I better get that person insured because if I'm not around, I want to make sure they're okay. The next thing I'd say is this. Well, sorry, I've got two more points and then I'll stop. So the next point is this. Contracts are very, very important in building construction. And one thing you learn very early when you practice in building and construction, and I was very fortunate to have an absolutely excellent building and construction partner I learnt my job under. What you learn very early is everybody will write the contract. Some people will put a small amount of time, some people will put huge money into it. Then what they'll do is they'll take the contract, put it over there, and just go do the work. And then everything goes bad and they go, oh, okay, what's the contract say? Now, not everyone does that, but it happens a lot in building and construction. Now, what you need to do is you need to focus on your contracts and you need to stick to your contracts. And in particular, what I'm talking about is this. That passage I read out as the last passage from the High Court, you're responsible for your work. You're responsible for your area of responsibility. So what you should do is be very, very clear as to what is your responsibility and what is not. If I am doing the tiling, well, what am I doing with the tiling? Am I doing the screed as well? Am I doing something else? If I'm pouring the concrete, am I also doing the formwork? Am I checking the formwork? You need to be very specific as to what you're doing. Now, someone might say you can't contract out of this act. That's true. But what you can do is only be responsible for your aspect. So you need to be very clear what is your aspect, and then what you need to do is stick to it. Be careful in how you do the work to make sure you're not overstepping it, and be clear that your role is only going to extend beyond that if it's in writing and it's all agreed. Then the contract clarity also needs to descend into your employment contracts and the roles and responsibilities of your staff. So take the foreman, for example. If I'm the company foreman for the head building contractor, what are my roles? Am I supposed to look for defects, or am I hired to not look for defects? Am I only hired to review quantity surveyor reports? What is my specific role? Now, if I'm the head builder, I can't get out of that, identifying defects, but I might want my foreman to be very clear what their role is. And when I say foreman, it's not foreman, not just foreman, it's any employee. You need to be very clear who's doing what and make them stick to it, or they're going to potentially be on the hook. Then the last thing I want to say is this. and this is the glass half full and the glass half empty. Indemnities. You can't contract out of this Act, but if you're a contracting person, you can get the people you're delegating to and entrusting to, if they'll agree to it, to give you indemnities or give you security. That's okay. That's not contracting out of the Act. It's just a separate relationship you have with that person, that if they do something wrong, they're going to cover you fully. You may not get that bargain out of people, but you would consider seeking it. The flip side, though, is you need to do your due diligence, because you might have people who are very happy to give you indemnities, but they're not worth the paper they're written on. So you need to make sure that when you get your security or you get your indemnity, it's of value. However, what you won't know is whether something of value today will be of value in 6 years from now, or 7 years from now, or 10 years from now. So you can't put yourself in a position where you've got perfect certainty as to how this is all going to go. What you can do, though, is use it as an opportunity to try and get these contractual terms in the state they should be. And other than that, you just have to pick your people you work with very carefully. You have to make sure you do your work very well, and to satisfy what this legislation is trying to make you do, you just have to do your job properly. Full stop. But for all the good intent in the world of doing your job properly, mistakes happen. So you need to know what you're going to do about that, and you want to get ahead of the game rather than find yourself losing in a court case with big costs and big judgments and the like.
All right, can you still hear me? Great. So what I'm going to do now, I've got some slides. I'm not sure whether these are going to be made available to you all, but yes, David assures me they'll be made available. So more than anything else, I just want to, first off, just concentrate and summarise Pafburn from a builder's point of view. We've heard two wonderful barristers talk about it and quote from the legislation, but let's do it the builder's way and just do a punch list of what this is all about. So the first part with Pafburn is the personal liability for subcontracted work. So at the end of the day, what this all means is, as a builder or a developer, you're it for the subcontractor's work. Okay, that's it, you're it. No passing the buck, no doing anything else, you're it. It's like that scene from The Godfather, Godfather 3, where Al Pacino is in the kitchen thinking to himself, just when I got out, they pulled me back in. So the builders are thinking, just when I thought I could spread my risk and apportion it out, the courts have pulled me back in. So it's all the builder now. The second point is the proportionate liability is unavailable. So I think you've heard that. You can't shift the risk anymore. So it's developer, builder, that's it. You're stuck with that. What the effect of that is going to have, now I'm going to come from an approach of construction, and part of my practice is actually we get involved in litigation. David's cross-examined me, and I've been with David and against David Weinberger, where we look at the court processes. Mr. Moisedes, welcome. What this does is that it increases the amount of cross-claims that's going to happen now. Builders are going to start thinking now, well, if I'm liable for everything, I've got to protect my risk. So I'm going to have to start thinking about subcontractors, and I'm going to have to start proceedings, separate proceedings. Now, they could be concurrent or they could be separate proceedings, but either way, that's going to increase costs. And if nothing else, it's going to be a lawyer's picnic, because the lawyers are going to start saying, but Your Honour, we have these proceedings against the subcontractors and we can't hear that, or we'd like to hear it together because it's the same evidence, And it's just, you know, not going to be wonderful for the lawyers. But that's what it is. That's what the current law is at the moment. And that's what it's now done. Now, the other issue is that what came out of this was interesting, the impact on consultants. I would probably like to say it's a little bit like election night, too early to call. But what my understanding of the proceedings were, the court decisions were that proportionate liability may be open to consultants, may be open to them. But as David and Tony have both said, that depends. That depends. There's a lot of issues going on there. And the last issue that Tony also raised was that the insurances are going to start going up. You've got to really cover your risk. Again, I'm coming from, if you want the glass is half empty, well, this is the law, this is what I'm stuck with, I can't change it, I've now got to protect myself. I can't afford to get Pafburn to turn me over. So, one of the things I just wanted to talk about very briefly, and I won't dwell on it very long, is just of the decision that was made, the judges that disagreed, where they disagreed was actually what was the definition of construction work, how far that definition went, and that's what Tony was talking about. That was one issue, and the second issue was the delegation of your responsibility to somewhere else. They were the two major issues that they spoke about. And he got translated. So the judges gave this wonderful example. They said, the dissenting judges said, think about this proposition. As builders, we engage specialist subcontractors. And the specialist subcontractors are electrical, plumbing. We don't hold those skills. Now, we are going to be fully responsible for their work when we really don't hold the skills to manage their work. That's an interesting thought. I want you to start thinking about that. So, where does that start leading you to? Some people might say, well, we've got to think of a way now, in construction-wise, to maybe hive those specialist contracts out of our contract, so we're not responsible for them. Question that I have that starts raising that is, how does a builder finish the building then if he's not responsible for the electrical or the plumbing? Yeah, this starts becoming a mind bender, a real mind bender. So somehow we're going to be stuck with the position that we're going to be responsible for people's work that we have no idea how they do it. And the dissenting judges actually were quite sympathetic about that. They said, in a real world problem, how does a builder manage that process? So that's one of the problems he's going to have. It is going to be a very, very difficult problem. So we've all heard about the DB and PA claim and so forth, and it's all new. What I'd like to talk a bit and draw to your attention now is what really is the difference between a DBPA claim and a Home Building Act claim. Because previously, the Home Building Act claim was, everybody did the Home Building Act claim. The Section 18B warranties, that's fine. So how does it differ now? How does it differ now with the DB&P? So, under the 18B claims, it was very simple. Very simple. As a consultant's job and builder's job, it was very simple. Did the building work comply with the contract documents? That's the first issue. As a consultant, you'd go out, you'd have a look at it. I'd have the argument with the builder. Why is this wrong? Why is the water stop at the bathroom threshold not visible? Because AS 3740 says it must be visible. Why is it not visible? Yada, yada, yada. And you start talking to them and you say, why are you doing this? This has been around for 20 years, this standard. Why are you still getting it wrong? But those are the issues. Did it comply with the contract documents? And what are the contract documents? You had the plans, the specifications, DA conditions, whatever was attached to it. Okay? Easy. Did the building work comply with the NCC or the Australian standards? Very simple process. You go out there, inspect, yes or no. Simple. How does the building work fail to comply? What did the builder do wrong? That's my favourite question. My favourite question, when I look at a defect, I look and I say, what did the builder do wrong? And what is needed to make good the non-compliance? That was an 18B claim, the Home Building Act claim, summarised. And I do apologise to the lawyers, it is oversimplified, but that I think gets the point across of how it used to be. Then we'd have the fight whether it was a major defect or a minor defect, 6 years, 2 years, and away we go. Now, this is how it's different. We've noticed in our practice over the last, within the last 2 years, we've had a lot of D, B and PA claims arising, where now owners' corps and owners are now suing builders under the D, B and P Act. Now, what does that look like? We've heard a lot about it, but what does it look like? So these are the type of issues we consider as consultants now. We consider as consultants when a claim is made. We now look at, in principle, what would a reasonable builder would have done in the circumstances. What would a reasonable builder do? What would a reasonably competent builder do? So, when considering the builder's responsibility, and when we do that, we actually have to spell out and we think about what should a building company's director do? And it's what Tony sort of said. Does he sit in his chair? Does he go out? Does he actually have a look at work? Or does he just sit there like the orchestra leader, just waving the baton around? But these are the issues. So now, I've got a sample here of a matter we did where this issue was the tiled flooring to a bathroom. It's the good old favourite, David. No falls, okay? Water doesn't get to the floor waste. Tiles have been laid at the wrong gradient, and it happens in the bathroom, the ensuite, the laundry, the balcony, you name it, we'll find it, and it happens everywhere. But the thought process is, under the home building, it would be very simple. What does AS 3958 say? What does AS 3740 say? What does AS 4654 say? Under a D, B and P claim, it gets a little bit more complicated. We think about, this is what a builder failed to do. And going from left to right, 1 to 9, he failed to review the architectural floor plans to confirm the external tile layouts. Did he do that? Did he fail to review the requirements within AS 3958 and 3740 relating to floor tiles and gradients? Did he do that? Did he provide the architectural drawings to the tiler and verify the finished floor levels and floor gradients of the tiled beds, tiled areas? Did he sit down and talk to the tiler and say, how are you going to do your work? This is where the heights are. This is where my angle is going to be. This is the height of the angle. This is the height of the corridor. So this is where your height is. You've got to work it out from there. Did he do that? Probably not. Did he inspect the installation of the tile screed to the tiled areas to confirm the gradients are required? Did he go and do that? I don't know how some of the builders do it today. In the old days, we'd get a progress claim from a builder, from a subcontractor, and one of the things we had to do was go and inspect his work before we paid him to make sure that the work was acceptable. That's how we used to do it. But today, you get a progress claim and it's all done, settled and finished in half an hour over the internet. It's all done, no one checks. That's my experience anyway. No one really checks what's going on. Did the builder fail to notify the tiler if the gradients were inadequate? What was the builder doing? Was he actually supervising the work? Was he supervising the work? or just letting the tiler run free, letting him go off on his folly? Did he wait for confirmation from the tiler if he identified defects? Has the tiler fixed those defects? Did they verify the gradients? Did he go back and check? Did he notify the tiler that the external area they could proceed? So you get a flavour of what these claims are, of what people failed to do, what they should have done, what a reasonably competent builder should have done. Reasonably competent builder through his supervisors, the foreman, the supervisors, and so forth. That's what that claim looks like today. So when you hear about a Pafburn claim and so forth under the DBP&A, it's a lot of these things that a reasonably competent builder and in instance of developers have failed to do. So now these gentlemen are now responsible, these entities now are responsible totally for the defects that are occurring. Totally. And how they manage that process now is going to be very, very interesting. Now, one of the issues where I'd like to go to from here is where to from here. I've given you a slight insight now about some of the defects, how they occur, the difference. I didn't do it. Defect. Yeah, I'm okay. Yeah, I'm okay with that. So, let's look at where to from here. Head contractors and developers retain liability for the work of their subby. So we've got that stuck in our head. So at the end of the day, for the developers and builders here, you're it. Okay? Congratulations. Welcome to the party. You're it. Secondly, you have to start considering and factoring into your business model the risk profile that you now have, and that risk profile has been elevated greatly. You have to start thinking about, if it happens, if the unthinkable happens, filing cross-claims. Who are you going to go after? And are they going to be separate? Are they going to be concurrent? I can see a situation arising where maybe some owners' corporation sues the builder under Pafburn, but does it very, very late down the piece. And some builder might argue, but hang on, had you got to me earlier, I might have had a chance now to cross-claim against the subby, but now I can't because he's gone to Havana and it's all over for me, you know. Well, life's hard. But that's what the law is at the moment. It's what it is, deal with it. The other thing is to think about with your consultants, the law is not real clear about whether consultants can avail themselves to apportionate liability. I don't know the answer to that, but there's lots of lawyers here in the room that could answer or put their mind to it at some point. Even the courts are sort of like, we don't know yet, jury's out. As Tony and David both said, a lot of parts of this act are still unclear. Now, the head contractors might want to start thinking about clearly defining the scope of work, picking up the point taken before, that they are willing to take liability for under a contract, be it a building or design contract with other consultants. So the issue you've got to start thinking about, what risk do you want to take on? And there's going to be risk that you're going to have an option for, and there's going to be a risk that you have no option for. You've just got to take it on. If you're building, you've just got to take it on. Then the question arises, how do you manage that risk? What strategies are you going to put in place? Now, as I said, I really want to prod your mind tonight to start giving you bullet points to thinking about what your business has to do, how you're going to do it. There's no template for this because everyone operates differently. Some people have wonderful QA programs, other people are still in the embryo stage and building theirs up. So what risk are you going to take? How are you going to hive it off? I can actually see it being very useful now if you actually got designers and consultants involved as well to start talking to your lawyers, but the construction people, construction lawyers, who actually start saying, help me, I've got this project, how do I do this now? But that also means also on the flip side for consultants as well. What does that mean as well for the consultants? What engagements are they going to take on now? What are they going to be responsible for now? These are issues that you've got to sort out. I mean, you could really hold the whole workday session. You could hold a planning session just on that alone. What risks are you going to take on? Obtaining advice from consultants, we spoke about that. The implement of site strategies for controlling the quality of construction work. This, I think, from the builder's point of view, is one of his major issues that he really does have to put his mind to now as a result of Pafburn. Many years ago, I don't know whether people remember, do you remember an animal called the clerk of works? Yeah, I can see the people with the grey hair say, yeah, a young lady as well, wonderful. The clerk of works was the bane of our life on site. We hated him. We hated him. Because he was the guy that would go around every day. How many men you got on site? How many bricklayers you got? Where are they working? And they'd go up there and they'd check the bricklayers and they'd go, that flashing's not in the right place. Fix that flashing. That cavity's dirty. Clean that out. And he had power under the contract to issue instructions to actually get that fixed. Now, we've often thought that bringing back as a strategy a clerk of works onto the projects could do very, very well for people, for construction companies. The cost of compare the cost of a clerk of works to the cost of making good defects is minimal, absolutely minimal. You could do that strategy. The second thing that this is going to now force contractors to do, no longer are you going to have what we call the hands-off builders, which should not allow the hand-off builders. No longer can you sit in your chair. Oh, the site boys have got it under control. No. You've now got to get involved. You've actually got to do what you're supposed to be doing and build and supervise and actually give your guys on site the Australian standards and hold in-house seminars explaining this is what the Australian standard says, this is what the Building Code of Australia says. Understanding all that. So you've got to start, from our point of view, start bumping up your internal training. Don't know how you're going to do it, because each organisation's separate. Many a time we go onto a site, we talk to the foreman. So, you've got some issues. Yeah, you've stuffed up a little bit under AS 3740 or 3958 or 2311, and they just look at you with a blank face. And you sort of go, am I talking Greek to you or something like that? No, mate. No, yeah, we understand what it means. So you quiz them a bit more. So what do you think? What do you think it means? And you just look at that stunned mullet look on their face and you just think, you have no idea, my friend. And that's unfortunate. Pafburn will start, I believe, should the good, responsive developers, builders, start increasing their in-house training. Technically and contractually in supervising what's expected of you from supervision as well. All it takes is a couple of hours a month or for half a day a month, you pull the team in. This is what we're talking about this month. This is what we're talking about this week. That's what this sort of stuff does, and Pafburn has to do. And that's what's propagated this. And that's a good thing for me. People will start building and start building properly. And the last item is undertake robust financial check of your subcontractors and security. This is unfortunately one of the half-empty, one of the terrible negative things. When you look at a subcontractor now, you've got to do a few financial checks on them. Are they going to be around? Are they financially stable? Can they do the work? Because if they go under, you're going to be left holding you will have no chance of any recourse. So you will be forced to do some work on that. So you've got to up your security risk on that to see how it is. That's all I've really got to say on that. I hope you
Well, I think reflecting on the chat tonight is that we should separate the DBP Act and the Pafburn decision. I think the Pafburn decision is probably more like a surround sound than what the DBP Act is all about. I think we should really focus on what changed as a result of the DBP Act. I'm not in the camp that's way over here on the right that says we should make a shitload of profit, or on this side that says no one should make any profit. I sit in that middle that says profit's not a dirty word, but you've got to earn it and you've got to do the right thing. What I have zero tolerance for is anyone who says that this is all about the media around Mascot Towers and Opal Towers. If anybody thinks that this is what this is about, then you're on the wrong bus. I personally have inspected over 300 projects in the 5 years that I was Commissioner. I went from top to bottom. And I've seen some of the most egregious construction that you could ever imagine. I've seen people's lives ruined. I've seen people living in absolutely shocking circumstances. And the developers who built them have generally got off scot-free. So I think there was a definite need for putting something right in the middle, the DBP Act. And I see my colleague, Gavin Melbourne here. If you want to throw stones at someone other than me, throw it at Gavin, because Gavin was in the House and actually got it through the House at the time. And the really, really great thing was that the decision in the House wasn't like the decision in the High Court. It was unanimous. There was no one dissenting from the DBP Act and the RAB Act when they went through. So there's no one half pregnant here. This thing is what the public wanted, and that's what the public representatives wanted. So don't ever have a doubt about the fact that the DBP Act is probably a long overdue intervention that stopped this race to the bottom. And George, you're starting to see the race back up now, and that race to the bottom just simply, we couldn't have carried on that way because simply our buildings would be unsellable. And from a state economic point of view, we were in the middle of a buyer strike. We'd gone from 22,000 apartments a year down to 14,000 apartments a year. Well, you get a treasurer's interest when you start to miss that sort of stamp duty. So this wasn't just a social thing, this was an economic thing. We had a buyer's strike. And I think we've got the balance right. We got the balance right. And I think it just needs a little bit more maturing, and you'll start to see an industry performing a lot better. So if you want to jack into every politician's ear and say, you went too far that way or that way, I'd say to you, pause and let this thing go another 5 years. Have a good look at it then. If you run the risk of you pull a few pieces out and you'll go back to a buyer's strike. You won't want that while you're trying to double the supply of housing. So New South Wales is now leading, arguably the leader in all of this, and other nations, other states in Australia are following. I'd say 60 to 70% of the developers have really embraced the DBP Act and are improving their businesses and their projects as a result. Consumers are coming back to the market. You don't pick up the paper every day and see, I recommend nobody buys an apartment anymore. That conversation's stopped. And I'll take issue with anybody who thinks this is driving the cost of construction up. Joy's another workshop for that, because I could unpack that and tell you that we are the most disorganised, wasteful industry you could ever imagine. And there's great opportunity to improve. So what we've achieved so far is that we're now seeing good designs being prepared, and so people are able to go on jobs instead of making it up. They actually know what it looks like before they go on the job. We can see that certifiers are no longer bearing the brunt of all of this, because certifiers are not the builder's QA system. They're not the builder's QA system. They have other decisions. They're a quasi-regulator, but they're not a builder. And I think you've got a respected and pretty proactive regulator out there now doing their bit. Another 3 to 5 years, I think, before you see the maturity of all of this starting to bake itself in. So for those who see themselves as victims, then you're probably the residual risky, because the guys that are becoming trustworthy are starting to see that, in fact, this is changing. And when I get round and talk to contractors today, I do this all the time, is that I can see that the ones that have decided to go that way are now telling me they've got their order books full, they've actually got the margins back in their job, and they're actually very pleased with the work they're doing. We also need to take this time to think about the fact that construction contracts were written in a different era. It's probably time to have a bit of a rethink about some of the elements of construction contracts, and again, another forum, not this one. But there's baked in expectations in building contracts or baked in interpretations of building contracts. Things should not change. Well, I'm not sure some people really understand the contracts that they're in. So I think that's another area that we need to spend a bit of time on. Construction's now a global business. When we buy a building now, we need to imagine that over 60% of that building is going to come from someplace else. It's either going to come from another jurisdiction in Australia, or it's going to come from another jurisdiction overseas. And it's going really, really fast. So I think that the north has been set in the DBP Act, and that is, it says, developer, you are the primary respondent that has to get this right. You make the holding out to a consumer to give you a deposit to build them an apartment that is fit for purpose and trustworthy. You appoint the designer, you appoint the builder, and you appoint the certifier, and you can make good decisions or bad decisions. So I have no sympathy at this stage for developers who are finding that a bit of a challenge. Get on board, because it's not changing anytime soon. Now, I've never been a regulator in my career. I've spent 50 years floating around as a builder, so it was my first Guernsey as a regulator, so it's quite a surprise. But I did actually start to study the subject of a regulator, because I think it's important. You can't actually be a building commissioner unless you spend a bit of time thinking about it. And what struck me was that we spent most of the last 5 years trying to fix everything that was wrong in the last 20. But we've got to start to think about what's coming over the fence. It's no good us having to have another one of these journeys in 20 years from now, because the game is changing so quickly. It's a global industry. There's changing building practices and technologies. Buildings are getting smarter. Buildings are becoming like a robot on a daily basis, and buildings are going to be making more and more decisions on behalf of the humans that are in them. So we need to start to think about what do smart buildings do. We're starting to see now that no longer are we going to be certifying all buildings as being the same. Insurers are starting to look now and say, how do I price that building different to that building, so that they can get some market recognition for more trustworthy buildings. So we're now seeing single asset recognition in the pricing of insurance, and that's going to bring insurance down, and it's certainly having a positive impact on lowering some areas of insurance that were out of control. For example, the increase in engineers PI in New South Wales has gone up at 30% less than the rate of all the other states in Australia. We're already seeing a dividend of the fact that New South Wales engineers are actually changing their game and becoming less risky. And you're going to see this new thing called market-led governance, and I'll talk about that before I finish. Now, what people need to realise is that the end-to-end accountability of a project now starts at the day that you want to put a project together. And you really do need to think about that, because it involves some decisions very early. So, for example, if you had a greenfield site, the decisions are a lot easier about organising the project on a greenfield site. If you're starting to think about a site that's a brownfield site, and it's either going to be a build on top of an existing building or some other engagement with it, then the due diligence that you're going to have to do about that before you start the journey, because that could bake in issues that go the entire journey that you're in. So typically it now will take you 5 years to go from the day you decide you want to get a DA to the day you get a key, and then it'll take you another 10 years before you can share all of the responsibilities that go with it. So sponsors of projects now need to think about the fact that everyone you deal with needs to become durable. I don't think you need bigger insurance policies or more insurance policies. I just think you need to have a look and see that, make sure that the people you're dealing with will be there while you're going through your journey. People also need to think about what that broad definition of developer is. Because if a landholder puts their land into a deal under a development management agreement, and the land doesn't get its money out of the project until the money starts to come in through settlements, then the land partner is in the deal. So some of these government SOCs that are currently trading other agencies' land and leaving some of it in to come out the other end because they're trying to prosecute the highest possible sale price, need to realise that then they're in the ring. So SOPA was in the ring on Opal Towers. Also need to think about what's changing with this buildings that are being procured differently and from offshore, and I'm just going to touch on that briefly before we go. And we need to understand that we are now facing into, this conversation's really been more about the transaction issues than the regulation. Regulators got a job to make sure that the regulations and the law have been applied. It's not the regulator's job to actually resolve the transaction, the building contract and the role of all the parties. So you need to realise that in fact the government's not that person sitting there with their arm around you saying, we're going to solve your transaction problems, and the transaction problems are changing dramatically. Now, I would just commend this piece of work to you just simply because if you go home tonight, you can download it and read it before you go to sleep. It's about a 2-hour read, so it'll keep you alive and awake. But what it's basically doing is it's actually a very good analysis by McKinsey of the changing value pools in construction as construction changes around and more work is moving off-site and offshore. These slides will be handed out to everybody, so you don't need to worry about them tonight. But I would believe that you should have a good look at this. So, for example, the overall pool of design fees may grow as the volume of buildings grow, but the amount of a design fee on a per project basis could come down if a significant amount of the design detailing moves to an offshore manufacturer. So I expect that designers' fees will come down, the volume of fees will go up, but you need to have a look and see just where the value is moving around. So accountability, end-to-end 15 years. I think this is a duplicated slide, so I'm just not going to... So here's the example I want to talk about. Here's a project that I'm currently looking at the moment. This is a building where it's going to have 500 volumetric modules made in China, delivered to site. The builder of record under the DBP Act will have to declare that it's seen the designs and upload the designs, including all the stuff that's been done off-site. And then that builder of record is going to have to build the substructure and the core and stand on the job site and wait for the trucks to roll in with the modules. 500 in this case. Now this is throwing up all sorts of questions because suddenly the builder's saying, I'm going to be responsible for all of this. The builder's saying, yeah, because I'm responsible for all of this. So there's some very, very interesting clauses here. So it's going to require looking at the clause to do with contracting out. It's going to be responsible to look at principal nominated supply items. It's going to be clauses to do with off-site payments because $40 million worth of boxes are coming to this job, and the building contract said the principal will supply $40 million worth of boxes, so you don't need to include that $40 million in your contract price. Quite surprised to find that in fact the tenders that they went out for came back at more than what the principal supply bid plus what they thought the builder was going to do. So there's quite a lot of work to do there, and right now there's a lot of risks that are moving around. You can separate that now from the DVP Act and from Pafburn because this is just simply the reality. If you're going to be putting a project together in the here and now, these are the issues that you should be turning your minds to. Not pushing back on Pafburn, not pushing back on the DVP Act, because this is the sorts of stuff now that's going to define the winners and losers of our industry. So Pafburn shouldn't be a target. Everybody says we're victims. We'll all be ruined, said Roon. They're all like that. It's just time we all faced into today's construction realities. The public do not believe that we are building a trustworthy built world, then we'll go back to a biostroke. Pafburn could be leveraged to the advantage of the good players. It could become a nightmare for those that don't understand what's happening. This is an important time to make sure the public is aware of the transformations that are going on, and there's this earnest commitment by, I would say, more than 70% of the industry in New South Wales today to build trustworthy buildings. The public should be aware of that, how we got there, and what they should be looking out for. We need to get academics to refresh their academic content because they're still teaching business as usual. In fact, some of them are not even teaching anything that's relevant to mankind. I offended some of the lecturers at Western Sydney universities and said to them, my observations in the first 2 years of building commissioner was that over 50% of the site and project managers on the jobs with serious defects were graduates. And I think I'm pretty right. And I asked them, had the graduation ceremony moved to the Easter show and were they being handed out on coloured cardboard boxes? Because you know what, some of these people were donkeys. They were donkeys. And how they got their qualification is beyond me. But they were taught by lecturers that didn't know, I'm going to say shit from shampoo, okay? Just so you get a picture word straight away. Australia's global competitors are unsentimental about what we think the laws are in Australia. They can shovel it in here and we suck it up, and they're going to say, problem be on you. That's the reason why we end up with the flammable cladding. I think the industry talked itself into saying it's okay. I think we need to be very cautious about what we'll accept going forward. What I'm seeing in some of the boxes that are coming in from overseas makes me lay awake at night. Now, I haven't seen many coming in from overseas in Australia, but I can tell you I've seen a couple in New Zealand, because New Zealand are 5 to 10 years ahead of actually exporting their construction industry to China. God help us if we do. But what I saw in the boxes in assembled buildings that were strata buildings. So there's one building that's finished and occupied. There's another building that's still got a wrappers on it, it's not delivered. One that's finished is a strata building. I can tell you it's got baked in problems that really concern me. These are not whimsical things, these are serious. It's got another building that is actually unable to be completed at the moment because it can't satisfy the regulator that it's actually fit for completion, and it's currently wrapped. But it's also been sold into the off-the-plan market, so it's got purchasers waiting who can actually drive down every weekend and have a look at their building wrapped in plastic, and it's been like that for nearly 2 years. So we need to go into this next period with our eyes wide open. It's not about throwing rocks at the DPP Act, and it's not about saying that Pafburn's caused the world another level of grief. It's just sharpening up the picture that the fact that consumers are highly invested in us building a better built world. Now here's another reality that I think is something lost on everybody. Wasn't lost on me. Because I had to go and argue the budget for the Building Commission through Treasury. There isn't any shekels in Treasury that are spare for it. They're likely to come out with less than more. But it makes you stand back and think, well, you know what? We got some additional money to stand up the DBP Act. We got 50 odd million to stand it up. So the Building Commission grew. But you've got to ask the question, how elastic is the government-funded regulator? And the reality is it's not an elastic opportunity for us to just simply grow the regulator. So if we go from 15,000 starts to 35,000 starts, that the size of the regulator is going to be pari passu with that. Not going to happen. And more often than not, every time there's a change of government, what do they say? First thing we want? Oh, we want a 2.5% efficiency dividend. So take 2.5% off the top of everything and we'll survive. We'll expect that what we've got is going to go under the knife going forward. That's just the way the process works. So what we actively did during the last couple of years to look at how can you actually create co-regulatory impactive tools? So hence you saw things like iCert ratings, latent defects insurance. You'll see far better CPD coming out of the professional bodies now. All of these things are co-regulatory in nature, and any competent regulator these days is going to be thinking about how can I do what I can do with what I have the resources to do, and how can I get a bigger impact beyond those resources. I'll be talking to a conference in New Zealand on this at the end of this month. But it needs to be realised that regulators are inelastic. In fact, if they're going to be elastic at all, they're going to go that way, not that way. And if we want to make sure our industry is in good hands going forward, we better start supporting some of these other things. So I'd like to see the conversation as we leave today to shift away from DBP Act. Really got nothing to do with the Pafburn decision. Take it as a surround sound. Shifting from people being victims to opportunists. So much joy going into builders and developers at the moment who are showing me the way they've turned their businesses around, the way they've bought into the fact that they want their mojo back and they don't want to go back to where they came from. And frankly, they have no sympathy whatsoever for some of those people that are no longer in business. Public record, the Dildooms, the Railings, the top places. Collectively, they were delivering nearly 2,000 apartments, defective apartments a year. They're no longer delivering those apartments. Now, there's still another number of players out there that are still delivering defective apartments, but these people did it with no shame whatsoever. And the fact that they're probably not, well, they're not doing it at the moment, that's a good thing. And it was bloody hard yards to get that piece of line in the sand. And I'll certainly scream from the sidelines if I see anybody moving that line or attempting to move that line back. Sorry about the lobbying of politicians. But I don't think, I've been around and seen them all since I've been building commissioner and retired, and said, are you likely to support any legislation to put the genie back in the bottle? And there's no way. So I'm going to be screaming, do not put that genie back in the bottle. Keep it out. So the focus now needs to go to project sponsors, developers, and we need to work out what we can do to set them up for success. And I can tell you now, everywhere I've been going in my post-commissioner role where people invite me to come and look at what they're doing, I can see people setting themselves up for success. And we need to become now agile in a multi-jurisdiction market where stuff is coming from everywhere. It really didn't dawn on me until I was commissioner, when I was standing on sites and certifiers are saying, well, Dave, we only see what's made on site. We don't see what's not made on site. So if it's a pod coming from Victoria or a pod coming from Dubai, what are we supposed to do? Well, that's the builder's QA system in my view, and they have to satisfy the certifier. I think we put too much burden on certifiers. They've got to do their job and do it a lot better, but it gets back to the project sponsor. You organise your project, buy it smart, you buy it right, and deliver on the promise that you made to the public to deliver them a trustworthy built world. Thank you.
All right, this is better. So what we are going to do is I'm going to ask a question of the panel, and then I'll give it to the audience, and then you can ask a question, and then we'll see how it goes, and we'll see how it develops. Here's the first question. I was thinking of Mr. Zakos. Mr. Zakos, Tony was talking about the fact that somebody in Germany might be liable in terms of a duty of care for providing or supplying material in Australia. I guess the question is, how can, in your experience, builders and head contractors avoid that kind of liability?
Thank you. I don't think it's a question of avoiding it. I really think it's a question of managing that liability. So if you're going to have something coming from Germany, and David brought up a good example, let's not stay in Germany, let's go to Dubai, where they're building bathroom pods. If you've got 400 bathroom pods coming from Dubai as a builder, and you're in Australia, I'll be quite blunt, if you haven't got somebody in Dubai checking it, you deserve what you get. There should be somebody over there checking it, going through the checklist. Is that done properly? Is that done properly? So it's a question for me of managing the risk, and the risk and the manner in which you manage the risk is directly proportional to what's at stake. If we're talking about $5,000, well, that might be a risk you're willing to take. But if you're talking about $5 million or $10 million worth of material coming from overseas, you really need to manage that risk. So that's how I would approach that.
Can I just give you an example, staying with the Dubai example, right? The Murhi project at Parramatta, that's the one I pulled up and issued a prohibition order on getting an OC, and I did that 3 years ago and it still hasn't got one. Isn't that great? So it was centrally around the bathroom pods. Now the bathroom pods, there were over 200 bathroom pods, but everything on that job was the same. The builder had gone and bought the fire doors instead of buying a complete tested fire door. He went and bought the frames because he was the cleverest man in town. Went and bought the frames, then shot the doors and bought the doors, and then bought the door furniture. I got to see over 250 fire door doors going to the tip, and having to go back to the original frame guy to sell him a tested door to go in the frame. And with the bathroom pods, there wasn't a single bathroom fixture that had a watermark stamp on it, not one. So they come all the way from Dubai, they've been paid, they've been installed, and not one had a watermark stamp on any of the bathroom wear. So they all had to be pulled out because the poor old plumber who connected them up didn't realise that it's illegal to connect up non-compliant plumbing. And so he nearly lost his licence, but the message was sufficiently conveyed. And for the membrane in the bathroom, it was ordered at 1.2 millimetres, and it was barely 0.4. Now, how do you buy stuff like that? And what I was given was letter after letter from the person who put the membrane down in the bathroom saying, oh, look, I know it was meant to be 1.2, but we think 0.4 will be all right. Well, hello.
Sorry. And funny you should say.
Not funny.
I worked on that project for the developer, trying to help him fix his problems. After you decided to issue the orders. So we landed, we got all these BWROs and all these orders about how these are things that are to be fixed, and we're trying to tell the developer, listen, you got a problem. But look, it's all factory done. It's all factory done. George, look at this video. And I'm watching a 15-minute video of the guys in Dubai in a factory putting down waterproof membrane. And I'm saying, well, there's a problem, and that's a problem. And when he's rolling the membrane out too much, because these pods, just very quickly, rectangles with holes on them, and so when they put the waterproof membrane down, they start at one corner, and that, David, it was 1.2 mil at the corner. But by the time they rolled out the membrane and came to the door threshold with the roller, the membrane was 0.4. And so that's where your problem is, and that's where your problem is.
Near the drain.
Yeah, well, we had to try and convince the developer to send people to Dubai and say, just, you got problems, because we had the windows tested. Remember the problem with the windows, they were leaking?
Come on, there's other questions.
Yeah, we had to send guys over there to watch the tests, because we didn't believe it. Anyway, that's the extent.
Thank you. Any questions from the floor?
I've got one for the lawyers. So say you're a construct-only builder and you've signed a contract which tells you that you're liable for any breaches of the DBP Act. It also tells you that if you're instructed with a variation, you have to ensure that the varied works comply with the DBP Act. How do you protect yourself then from the fact that you're not designing it?
Comply.
No, but you're not designing it, and you don't have any contract with the consultant or any control over what the consultant has done.
Stop work. Well, but the question is an exercise of reasonable care. So what's reasonable care in those circumstances, right? So if it's defective building work.
What I was proposing is that we ask the clients to give us an indemnity that their design complies before, in the actual contract.
I suppose you could ask. I suppose you could ask the client that. The question which may arise is because you can't contract out, does that and could work against you? So in theory, if you could run an apportionment defence, I'm not saying you could, but if you could, then that would be contracting out. Otherwise, yes, perhaps an indemnity is the way to go. But realise it's always about exercising reasonable care. It's not strict liability. But if the person who's carrying out the work, right, is your delegate, that's when you're liable for their failure to exercise reasonable care.
To the builder, you're not the developer in this scenario.
Yes, you're the builder, yes.
Yeah.
And
you've got no relationship with the designer.
And the variation is for what?
Different scope. Same design, it's designed by somebody else.
Right, but that's my point. This is the important distinction in terms of reasonable care. It's a construct-only contract, not a design and construct contract. So if it's a D&C and you subcontract the design, that's delegating the duty. But if it's construct-only, and if I understand your question correctly, you're given a variation, call it a design variation, then it's difficult to see how you could be guilty of failing to exercise reasonable care if you're just following a design. It doesn't have to be a variation.
But you're being asked to say that the works will comply with the Act.
But that's got nothing to do with the Act. And the work...
Just to clarify this though, the design has to be declared. So the variation, if it's for one of the key building elements or it affects another key building element, the design has to be declared. Now, if the builder hasn't got a declared design, then he should reject the variation outright.
But I think the question is, assuming you've got all of that, then what? That's really the question. If it passes all those hurdles and it's declared and it's ticked off and it's still found to be defective, I think your question is, well, how does the builder avoid liability?
So if the variation clause is a mandatory one, where you have to perform it, and you can't ensure that the design is compliant.
But this is my point, whether it's a variation or not, in my view, it doesn't matter, because if the builder is given a design, or a material is specified for the builder to install, let's say cladding is specified, particular cladding that has 99% polyethylene and is combustible, hypothetically, and the builder doesn't know better, or shouldn't, acting reasonably, know better, then there's no negligence. And there's no delegation. It's not contrast a situation where the builder engages a subbie to do the builder's work. Here the builder's just following a design or using materials which it reasonably considers is suitable, whether it's a can of paint on the shelf that happens to, later be the subject of a product recall, or pipes which, there have been a lot of cases about defective pipes in the last few years. People thought these pipes were suitable for hot water, but they were only suitable for cold water. Builder is not expected to know better than the manufacturers themselves. So in that case, in that scenario, there'd just be no negligence.
I would dissent from that view.
Right?
It may well still be a breach of contract.
Yeah.
But that's separate, completely separate from the Act, and would apply irrespective of this legislation.
To perhaps, I know, Tony, you want to answer that question, and you're really eager. But before I'll ask you a question, and then you can answer this other question together. The magic words delegates or entrusts. Now, a lot of people say that developers are not going to be responsible because you can't really prove that they've breached their duty of care. Is it enough to prove that their subcontractors breached their duty of care? And then the developers become responsible. And so you can piggyback on that question with the LRM there as well.
So with the question that Richard just asked, the answer is yes. Sure enough. Now, I think the interaction between Part 4 of the Design and Building Practitioners Act and Part 4 of the Civil Liability Act and Section 5Q of the Civil Liability Act is what Pafburn was about. What one might say is a simple way of putting what does all that mean, I think is this. If you are responsible for an aspect of the construction work, you have a duty to ensure that everybody to whom you have delegated or entrusted any aspect of that does their part of it carrying out reasonable care. So if they are negligent, you will be responsible for their negligence because it will be a breach of your non-delegable duty. And under Section 39 of the Civil Liability Act, you're just as liable for the loss as they are. Now, if you say, but I the developer delegated to the builder, I didn't delegate to the subcontractor or the subcontractor, Pafburn says it doesn't work that way. If you, the developer, delegated to the builder, you're responsible for the negligence of that person, the builder, and whoever else they procure by delegating or entrusting to get the job done. And just on that question that was asked about the variation, the issue that I was talking about was defining the area of responsibility. So the High Court decision in the majority talked about you're responsible for your work, or you're responsible for overseeing your part of it. So one way to manage that problem is to get ahead of it before it ever happens and approach the contract with precision. It's very easy to want to get things out quickly, to get things out cheaply. Those days need to be stopped, and people need to give a lot of consideration to what exactly they're agreeing to do. So in that scenario, if you're only agreeing to do the physical building work and you're not agreeing to do design, that needs to be clearly spelled out, so you can't be snookered, so to speak, with the scenario that you said about this variation being forced upon you. With the importing of the pods, you have to exercise reasonable care to make sure that the pods are as they should be, if I can put it in simple terms. Now, the examples that were given were very clear examples where things were obviously not compliant with Australian standards or obviously not compliant with what was ordered. It gets harder where things are not so obvious. So, for example, you've got some porcelain sink or porcelain toilet, and it all looks fine, it all seems all right, but there's some inherent flaw in it with the hairline, with some sort of manufacturing flaw. Are you responsible for that? Well, under the Home Building Act, there's warranties that it's supposed to be fit for purpose. Under the Design Building Practitioners Act, you have to exercise reasonable care. Now, it may be that exercising reasonable care would never have picked up that design fault, and so you're not giving an ironclad guarantee that if this thing breaks, you will be responsible. But it's a question for each situation as to what is reasonable care and whether it's been fulfilled. With the importing of the pods, some facetious person might say, well, if you're the builder or you're a subcontractor, whether it's pods or anything else, you need to make it clear in your contract, I am not supplying this, I am only being hired to install this. You are buying it, you are supplying it, I only install it. That might be one way to manage the risk for the builder. The developer acquires it, and I'm only hired as the builder to install it. But I need to exercise reasonable care. And it may be that there's something obvious that even when I'm installing, I should have raised. And if the developer said do it anyway, question mark whether I'm negligent if I follow that instruction or not. Maybe the contract needs to say a way to deal with that.
There's a public interest issue there, Tony, and that is, the other rule is you can't unsee what you've seen. Okay, so too often people are just flagged away and
And so I talked to young engineers who've seen stuff and reported it, and nobody's listened, and so they've just gone on towards the end where a certificate's required to say the structure's okay. You say, but you can't unsee what you've seen.
So what this Act is doing is encouraging you to not be a people pleaser and to just say no. And as we all know, it's hard to put up with key group pressure, and it's hard to be the lone voice standing up against all the people putting pressure on you. But unfortunately, the ramification for just going with the flow is that you may be liable, or your company may be liable. So the incentive is people have to take the very hard path of saying, no, I'm going to do it properly. And if that means that these people won't hire you anymore to do the work, maybe that's in your best interest, because the money you make today, you're going to lose tomorrow on the litigation, or you're going to lose tomorrow with loss of reputation for being associated with a very bad building.
Correct. And it goes right back to the beginning too. So I've got
An exhibit where one of the top 5 engineers in the town accepted a structural engagement for a small job and quoted a fee of $35,000 to do the design and $27,000 to do the inspection. And when I called in the contract to look at the contract, because I had the powers under the RAB Act, there was a line put through the $35,000 for the design, reduced to 27, and a line through the inspection services from 27 reduced to 15. I said to the engineer, you know that wasn't enough, but you signed the contract. So where do we sit there? Well, they've got nowhere to stand, have they?
Yes, but that's the practical result. The legal result is, well, they can be held to their contract. If they did it for a cheap price, they still have to do the job properly. Well, I've had cases where people have been acted for, particularly homeowners, and you have a builder say, well, for that price, what did they expect? And I can remember one in Fairlight where the drainage was just completely wrong. Instead of cutting down into the rock, putting in the ag pipe, putting in the blue metal, what the guy did was he put the ag pipe on top of the rock, he put all the rubble from the spoil on top, and the drainage eventually went bad. And his response was, it was a good job for the price they were paying, even though he contracted to do in accordance with the drawings. So that's the kind of bad behaviour everybody wants to stop. The question is this well, for me, for my part, whether this legislation goes too far to achieve that result. But I think
it doesn't touch the sides.
and that's our respectful difference of opinion. But I think the reality is anybody in this room, when buying a property, wants to know that that property is built properly and is going to last. And if you put yourself in that position, you want to build things properly. But it all has to be within the realms of reality. You don't want good builders going bankrupt or into liquidation because they've been dragged into litigation unnecessarily, and the whole process just sends them broke. But you also want builders to build things properly.
But just to put it in the consumer's perspective though,
The 280 bathrooms that got pulled out on Top Place's job when I was first appointed at Botany, we tested 5 bathrooms and I picked 3 out of a hat, to pick them randomly, and we let the developer pick another 2. And he was still angry, saying that I got lucky, that I just happened to find 5 bathrooms out of 280 randomly selected that didn't comply. Ultimately, he agreed that he'd pull out the entire 200 odd bathrooms and redo them before completion. So we did it in quite a good spirit, I have to say, and I respect Top Place for doing this, and I respect the on-site team. But because I wanted to unpack it some more. I said, you know, you had a really, really good design for these bathrooms. The design was fantastic, it complied, it was just fantastic. But they've let these low-cost prices to do the trades, the sheet walling and the plastering and the membrane. And I said, what do you reckon you saved by screwing it from doing it right to doing it what you've done? So they went away and they thought about it. They came back and said, Commissioner, we think we saved about $1,500 a bathroom by cutting the corners that we cut. I said, okay. So what did it cost you before completion to go and fix 200 odd bathrooms? And Commissioner, we've worked it out already, it cost us $15,000 a bathroom to fix them. And then we talked about what would it cost a consumer after it was finished, when it was occupied, and the cost was $35,000 a bathroom. So here's $15,000 worth of nickel and diming, costing the developer $15,000 a bathroom, over $6.5 million. Big numbers. Imagine what it would have cost that owners corporation.
We weren't tough enough, were we?
You were.
Everything you said I agree is valid. The risk though is you can pick the absolute worst players and they prove the proposition. But are they the rule? Everything's usually on a bell curve. So the shape of it depends on what you're dealing with, but people who in effect are con artists or unscrupulous people who will be in any industry and have always been, time immemorial. And those people, any consumer wants to see out of any market.
But let's, but you're saying the bell curve, it doesn't work that way, Tony. The most high risk defect people now are people building under 5-storey buildings that have come across from class 1, who've never built a class 2 building and think they can build the Empire State Building. That's where the highest density of non-compliance is right now. It's migrants from class 1 into class 2.
That may be so, but the proposition I'm putting, and everyone will form their own view, is has the government used a sledgehammer to put in a nail, and with the very appropriate moral outcome of trying to get rid of bad builders, is it now going to, as collateral damage, hurt good builders? And time will tell.
We can respect
If you're a good builder, there's probably not many defects.
Thank you very much. I was hopeful that there was going to be agreement between Mr. Greg Chandler and Mr. Tony Francesco. I was sorely disappointed. But any questions from the floor?
I think it's been touched on a bit there by Tony, and it's really questions what is virtual happening in the lawyer's views. There's obviously been a change with the DLBP Act as to who bears the insolvency risk here, and that is now really quite squarely on the builder developer. I'm not suggesting that that should change, but what are the panel's views on how a builder developer can mitigate its risk in the insolvency space, noting that the insolvency legislation and enforcement is probably quite a few years behind this. There's perhaps not a regulator or authority that will be able to prosecute phoenixing activity. And it would be interesting to hear the panel's views on how that can be dealt with in the current climate.
Well, I'm very large.
And, well, I was going to go to you first because...
well, I will deal with the question, but, you know, ATSIC's a sleepable bill, right? Basically, they're just doing the bus over the side of the cliff, they're out to lunch. Same as ASPO, right? ASPO the same. So, faced with that problem as a commissioner, and I had to chase these insolvents, these phoenixes out of town, the only option was to go and find a market-led solution, which was the ISID solution out of Equifax. Now, I can't get a competitor to come into the market to compete at the moment, and we will, but the market's getting big enough to do that. But right now, the best thing that everyone's got going, consumers, developers, builders, is an ISID rating. And despite all the noise you hear, let me tell you, the people who haven't got it are not the people who don't want it, they're people who are trying to get it, and they just haven't cleaned up their balance sheet yet. So it's making a huge difference. But there is an unintended consequence, and it's become a slight barrier to entry for new entrants. And next week I'm working on creating a silver rating for startups to come into the industry so they can have a silver rating for 3 years. But I think what we're going to try and do is to realise that government's never going to sort out trust.
Government deals with risk. It doesn't deal with trust. So that has to be a market-led thing. And one of the shortcomings of the ISO rating system is it's good if you're an established player, but it doesn't give you the on-ramp if you're an entry. So next week we're starting on working out what's a silver rating, and I reckon we'll have that by the end of the year.
Related, before I move forward, related to that question, there's an issue of stepping rights. I think somebody raised this before in relation to financiers. What happens to those people?
It's been quite a rude awakening to financiers taking possession of sites where there's serious defects. Let's talk about the Murphy project at Parramatta, where the receiver appointed there stepped in and came into a meeting and said, you know, I'm protected by the laws of receivership, and that's a Commonwealth law, so Commissioner, there's nothing here for you. And I said, well, that's fine, but I happen to regulate the country called New South Wales, and we're going to tell you that you cannot have a certificate of occupancy till I say so. So when you finally get that into your thick head, then we'll talk about doing that. And by the way, you may think that you have been indemnified by the lender who's appointed you, but you have stood in the shoes of the developer, and you are the developer as far as I'm concerned, and you will be held responsible as if you are the developer. Now that message has gone through the receivers. They've finally got the message. When you step in, you are the developer or you are the builder. So they're starting to behave in a very different way, and guess what? Lenders are becoming far more mindful not to lend to bad players. So there's a whole lot of another 3 to 5 year maturity going on at the moment. So that project at Parramatta, I'm told it's within 2 or 3 months of being finished over the 3 years. And we did a voluntary enforceable undertaking because we didn't want to go through the courts. And the lender agreed to go into a voluntary enforceable undertaking. They handed all the deposits back to the purchasers, and they agreed to put the project into a BTR for 10 years. Because we thought what they should do is to walk the first 10 years of liability in the consumer's shoes, and then they could bring it back to the market. So that's what's happening at Parramatta and a number of other jobs. All that's doing is resetting the compass. Tony, you would say it might be a bit of overstepping of someone using their powers without the powers being supported by legislation or really tested. But when you're confronted by the fact that once we've issued a prohibition order, it stands until you have it overturned in the Land Environment Court. It's pointless going down there because you don't win many these days there.
Well, I think the legislation is so broadly worded that it can capture the scenario of the person who steps in and starts wrong things. Receivers and managers would need to try to look for some sort of protection in the Corporations Act, but I'm not sure they have. Well, I don't think they have one. And if they come in and are a receiver and manager, as opposed to just a receiver who just stops all the work and sells everything up as is, I think they're taking on a very significant risk of being found to be owing a duty of care under Part 4 and elsewhere in the Act. In terms of the insolvency aspects, I do a lot of fraud cases, I do a lot of corporations cases, and from my personal point of view, I think phoenixing is a real problem and a very big problem in this country when it comes to looking at it in terms of protecting creditors who end up getting fleeced, and then that has a knock-on effect for their businesses. There's probably an element of people that would look at phoenixing as, oh, well, that's my solution to the Design Building Practitioners Act. I'll just set up a little safe haven that I can leave this company behind, leave all my debt behind and move on. That would not be what the legislation is aiming at. The legislation...
An ICERT rating. If you've phoenixed any time in the last 5 years, you will not get an ICERT rating. So the prize for phoenixing is, good, go and join the crowd in the blitzes.
That's right. So if you're looking for legitimate people with a long history, you're not going to go for the people with Phoenix. If you're at the other end of the market where you're behaving badly, you might think this is a really good thing. Eventually, that behaviour will probably catch up with you, and what the Design Building Practitioners Act does is potentially, and we've already seen cases doing it, pierce the corporate veil. So you go along in Phoenix and you think, oh, I'm safe, and then all of a sudden the director's getting personal liability. Didn't work. So then what would unscrupulous people do? Oh, they put in some dummy director and make that poor person the victim. It depends how you look at it. If you're...
It's up to their lender then. If they want to lend money to people like that, they're unlikely they'd be able to get the settlement. So the bottom line is the lender can do the lifting for the regulator.
It's all there. This legislation is trying to incentivise people to do the right thing and trying to put up roadblocks that will stop people dealing with these people. I mean, hopefully it'll work, but I go to court, I go to NCAT, and there's more than ever, there's not less. And, you know, we've had the commercial list in the Supreme Court in one division or one form or another for more than 30 years, and it's always been full. So Design Building Practitioners Act came in now, but that list has been around for decades, and it's always been full of, not full of, I mean there's other cases as well, but a lot of it is defect work. So these are very serious problems, and they're very complex problems, and I suspect the legislation of itself won't solve it. But in terms of insolvency, Phoenixing is a real problem. And if you're, for example, a subcontractor and you're a small business and the head builder Phoenixes, you may lose your whole livelihood, and that would be terrible. Then also in terms of insolvency, what this legislation does is it gives the owner the ability to sue, if I can put it this way, everybody. And so the owner's got the best chance of recovering their loss, because hopefully for the owner, if they get enough people, between those people they'll eventually get their money back. The risk of failure to recover then falls on the people getting sued, so the builders, the developers, subcontractors of this world, engineers, etc. They're running the risk that when they go for contribution, the person they get a judgment against is not good for the money. Now that's not an accident. That idea of the owner can sue whoever they like, and then that defendant cross-claims for contribution is what's called solidary liability. And that was the norm up until about 2002, when the insurance companies in this country were complaining that everything was too expensive and they shouldn't be liable for the whole lot. And there was a complaint that allegedly there was a view that every plaintiff wins a prize in courts. So the Civil Liability Act came in and introduced proportionate liability. And then that was the norm for almost 20 years. And then when this Design and Building Practitioners Act came in, the tension as far as, say, David's client and my client was, is it solidary liability or is it proportionate liability? And the judges were divided, and ultimately, by a very narrow margin, solidary liability won the day. But what that is the Parliament making a decision that we're going to...
Unanimously.
Sure. But unanimously in a piece of legislation that judges were divided as to how you read it, reflective perhaps of a rush. But anyway...
What was overdue?
I agree something was overdue. It's not necessarily this, but anyway, the point is, the way the law is it's favouring the owners and putting the risk of non-recovery on everybody else. If it was proportionate liability, it would have been the other way. The risk of non-recovery would have been on the owners. However you see that, that's the reality of it, and people have to be alive to how they're going to deal with that.
Can I just say something which is not responsive to any particular question? There seems to me to be a degree of fairness in the legislation insofar as being able to sue, including developers. You're a developer. You build a block of apartments, you sell 100 lots at $1 million each, I'm just making up an example, of course. And then you want to say, well, you should be off the hook for your product. You should be immune from suit. You shouldn't be able to be sued. That's well and good, but I think there's something to be said for some degree and I'm not on any particular side, I ain't for owners, I ain't for developers, I ain't for builders, but I think there's something to be said for developers being held accountable for their products, like any other supplier of goods and services. Why not? Why should the developer be immune if the developer is in fact selling the product, apartments off the plan, and there are other purchasers, subsequent purchasers, who are buying apartments in good faith, thinking the developer has ensured that the product, the block of apartments or the house, is in good nick. And the other point is, what is wrong with an owner's corporation or a homeowner being able to sue the waterproofer directly or the engineer directly and not having to enter the legal quagmire of whether there's a duty of care? And it's a very complex test, i.e. vulnerable, proximity, all these, this calculus which goes into determining whether a duty of care is owed is so vague. Isn't it a good thing that there's legislation which now says, well, you don't have to worry about that. You can sue the engineer even though you didn't have a contract with the engineer, or you can sue the waterproofer even though you didn't have a contract with the waterproofer, without having to worry about duty of care. And can I put it another way? If you slipped on some stairs and broke your ankle, you could sue the architect or you could sue the builder if there was a defective design or a defective installation. Because if it's physical injury, there's no doubt there's a duty of care owed by the engineer or by the architect or by the builder. But why not if your home, which you've bought for many thousands of dollars, is falling down? In those circumstances, why shouldn't you be able to sue the waterproofer or the engineer or the architect or the supplier of the cladding? So I think there's, put aside, I'm not taking it aside on the sentiment as to whether the legislation's gone too far or not far enough, but at a level of principle, I see a great degree of common sense, if not at least fairness, in being able to sue these entities directly without getting into the question, the complex question of whether there is a duty of care or not.
The question there is, why should an unsophisticated purchaser have to go down that pathway? They should just go straight to the developer who sold it to them. Full stop.
I agree, but if the developer's gone under, my point is if the developer's under, the builder's under, as happens a lot of the
There's
time.
no other recourse than possibly look at that until that case exists. You see, the other problem we've got is lawyers. I made a promise to lawyers that they should contemplate taking their children out of private schools. We were going to close down the number of litigation. I'm pleased to report to you that as of January, just after I retired last year, so January this year, there's been a 40% reduction in matters that have gone to NCAT. So, you know, while you're seeing the backlog, I can tell you that the numbers of matters going to NCAT are starting to come down. So that's starting to show the maturity model here. But I just don't think that unsophisticated owners should go on a journey. Because when I talk to the waterproofers, so this is what this all started. The waterproofers were so beaten up by these developers. I'm not going to name the developer in this instance, but it's one that you know. And this waterproofer took me out and showed me, he said, Dave, come and have a look at this. He said, all of this deck is leaking. I refused to put waterproofing down on that. It was covered in water, there's no falls, no nothing. The developer owed me $300,000 in progress payments, and he said, if you want to see any of that $300,000, mate, get some bloody membrane on that right now. And he said, so what do you do? I've got a house to pay for, I've got kids to feed. And so they go with the flow. So how would someone suing that waterproofer deal with the fact that, well, he told me that this particular developer said to me, mate, don't worry about 10 square metres per 5 litre drum of stuff. Spread it out to the Opera House. And that was from Mortdale, right? So Mortdale and the Opera House, he reckoned he could spread that distance.
Well, I think the answer, that's the risk of business. If the waterproofer was $300,000 behind, he shouldn't have got into that position in the first place. But my point is, yes, you sue the developer and builder first. I see many instances where the builder and the developer have gone, right? So the owner's corporation is left holding the baby, if you like, and in those circumstances, my point was, if it wasn't clear enough in those circumstances, I see great fairness in the owner being able to sue the engineer who caused the building to collapse or the waterproof, there's one that's got more than $2 for the effective waterproofing. That's my point. So it opens up a broader horizon of targets. If you're an owners corporation, if the primary target, the builder, the developer, have gone up.
It gets so complicated by the way that these contracts are awarded. So if you take a structural engineer, for example, who's been engaged to do vertical, not horizontal, so some of you will understand what we're talking about here. It's the engineer's been engaged to do all the load-bearing vertical elements, and the developers decided to subcontract all the post-tensioning to another contractor, D&C subcontractor. Now, the hideous defects that result as a result of the lowest price post-tension contractor being told to put post-tension slabs in and connect it to the verticals. Now, when they have to be rectified, they change the entire load arrangements in the structure. They actually have to stiffen the slabs up so stiffly that they actually put another load on the columns or the verticals. So if you were trying to suit just the horizontals contractor, the verticals was almost an innocent bystander. So it's so complex. So my view is if you can get the developer, get them a get them a
You have a question?
Yeah, it's been ventilated.
And
Thank you. I agree with David that the catch-all liability ought to apply, just from a layman's perspective. The question is that if someone's buying a multi-million-dollar apartment and ultimately the developer or the builder who's made the profit on those sales ought to be held ultimately reliable. And either top down, bottom up, side by side, whoever's involved in that chain is ultimately responsible in some way or another. And having the consumer not having to meet all the minimum thresholds about proof and being able to now rely on this act to make a claim, I think is a great thing. If you're a dodgy builder, well, you're going to be scared, you're going to run away. But if you've got nothing to hide, I don't think that will be a problem. In the real estate profession, the fair trading have got inspectors that periodically go to real estate offices and do spot checks on their trust accounts to see whether their books are balanced and reconciled. Would it be beneficial to have, I think George mentioned clerk of works or worker clerks, have building inspectors do the same thing from fair trading to go out and do a whole series of spot checks and then issue fines and stop orders that will potentially put the builder on notice to do the right thing. And would it be beneficial to have the service engineers that have prepared the structural drawings and the hydraulic drawings and plumbing and the acoustics and the whole gambit of planning experts to attend the sites and the construction works periodically and to sign off as the authority on those works as opposed to leaving it to somebody else? And then the other two questions I had was basically the retention monies. Ultimately, would that be, I guess, a possibility to increase the retention monies that the builder's got to put into the project, increase those so they have to do the right thing, not have claims made against the subcontractors, so he can ultimately get his profit after 3 or 4 years or 5 years.
You've got about a dozen questions.
Yeah, I've got a lot, yes, sorry.
So can I just answer a couple because I've got a short-term memory problem. I've got a long-term memory.
The building issue.
So I'll go backwards with your question first of all. So retention, but let's talk about a strata bond, the strata bond scheme. Strata bond scheme is flawed. Okay, so in my view, it's an imperfect solution to a problem because essentially the good guys go and do the defects to get their strata bond back. The bad guys see the strata bond as a cost of construction, so they have no anticipation of getting it back at all. So they just strip more out of the construction cost, saying, see you later, we don't even want the strata bond back, we're out of here. Whereas the good guys, they have to wear the strata bond on their balance sheet till they've finally got it back. Okay, so it was an imperfect solution. So it was clear to me from the start that we needed to bring that 10-year warranty insurance into the market. Now, it took a while to get the first insurer, but there's now 5 just about to be in the market. So by the end of the year, I expect we'll have 5 offering 10-year warranty insurance. Now, what all of the LDI insurance policies require is that the developer engages an independent technical inspection service. Now, that TIS goes from the creation of the drawings all the way through to the end. And the TIS, which is a surrogate for a clerk of works, if you like, has to issue a certificate to the insurer to turn the policy on at the end. So if the TIS service provider doesn't issue the certificate of compliance to the insurer, the 10-year warranty insurance policy doesn't get turned on.
Wouldn't that be too late for that?
Not really, no, because if you make that as a condition of settlement, then until you've got that policy, then you don't have to settle. So, look, I think, as everybody here said tonight, we're dealing with some immature legislation that can be better by passage of time. We've got to be careful we don't hit the wrong part of it on the head. But I agree with Tony and others that we can make improvements to this to make it work better for everybody. First thing I would do is to exclude homeowner builders out of it right now, because I don't think anybody knows how to deal with that. But I can tell you that it's rich in the western suburbs, that there's a whole cohort of people who get a homeowner builder's licence, and there's an Indian builder out there, and he just rents their licences. Okay, and I can tell you that the houses are a nightmare. We can't fix everything in one go. Let's just keep the maturity moving, and I think it's going to get better and better.
George, you've been quiet for a long time. I was going to ask you, how do we get the Rolls-Royce solution with as little cost as possible? With no real experience, you may be able to help us.
He's the one.
Thanks. How do we get it? Look, the only way, in my mind, you're going to get a decent construction is to actually do the work properly in the first place. And it costs money to do that. You know, the argument that you said, the issue that you brought up before, where the builder said, well, you know, with the utmost respect, what do you want for the price I'm charging? That's just such a stupid argument. It really is. It shows you the mentality of where people are. So for me, I think it's the mind shift. You know, you ask the question, how does someone get a Mercedes-Benz when they just want to pay a whole new price for it? That's been the age-old question forever and a day. There has to be a bit of mind shift in the market to say, look, if you really want something done properly, it's going to cost.
Come on.
Yeah, it is though. When labour rates at the moment are $91 an hour for a carpenter, it's going to cost.
Toyota sell a Corolla and a Lexus.
At the end of the day, it's never going to happen because it's cost versus time. The banks aren't going to lend on something that all of a sudden the contract's gone from 2 years to 18 months. The builder is forced into a condition whereby the PMs, where they say, can you do it in 12 months? The builder says yes, it's still going to take him 15 months. One of the best solutions, and I've seen practical cases because a lot of the big retirement people are doing it, is your clerk that works on site. The police guy on site, it's the closest thing you'll get to it. At the end of the day, until people are willing to spend money on it, until the builders are willing to give time, time equals interest rates and costs on your loans. Not going to happen.
Leave it at that.
Thank you.
2 more questions from the floor and we're done. Anybody? We're talking, as I said, at the big end of the deal, you know, large projects, large unit blocks.
have we developed in the model that's there at the moment something that's onerous for the owner of a unit who wants to do some renovation? Have we put in so much procedure and so forth in there that it becomes a significant cost in that line? And if I might just tag on the other question, what's people's thoughts about the liability of owners corporations, the strata committee meetings, if they're actually approving designs as part of the process to cripple the project?
So, Tony, are the owners corporations developers?
Well, you look at Section 37, you look at Section 36, and you ask yourself, what are they doing? So they are approving a design, they're approving work to be carried out a certain way. Is that construction work in the sense of something relating to a design? There's people who would say, no, it's not. All they're doing is just letting people do things. The counter argument, which I prefer, is they have a say in whether this is going to be allowed to proceed or not, and whether it's going to be allowed to proceed in that form. So they have a form of substantive control over whether that design is going to be built. So yes, I think they are for it. Was the legislation intending to do that? I don't know. I would assume not. But it's another one of these unexpected, perhaps, side effects of the broad wording that's there, which comes back to the point that I was raising. I think this is an issue that Parliament needs to address to give clarity as to what exactly Parliament intended to be the scope of various aspects of this particular aspect being who is the person with this duty and where do you draw the line.
We are facing into a period where some stratas are going to become developments. So there's a project out at eastern suburbs where they had fire orders and they couldn't pay for it. So they decided to add 2 floors to the top of the building and 100 car spaces in the basement. They inadvertently didn't think that they'd become a developer. They'd sold 2 $40 million penthouses on the top. And they had a prohibition order because they couldn't get an occupation certificate because they hadn't done anything right. So there's that particular issue. But on the other side, we've got some very large backlog maintenance and serious defects in some of these buildings. And I know that the remediation industry is pushing back a little bit at the moment, saying, hey, we've got to go and do clear the lines. But I can tell you firsthand that the remediation industry is the Wild West. You can be doing Bob a job one day and doing waterproof and structural repairs on an apartment building. So we had to bring that into some sort of observation and control. Now I think that will find a sensible level in due course as well, because there's no reason for owners corporation to go beyond the pale. But my goodness, some of them are trying to do just a brush over to say, oh, make it look okay, then we can sell it and move on. And that's not the answer either.
Final question from the floor. Anybody? No? No questions? All right, I might ask a question.
What about the Lord's Prayer?
Sorry?
What about the Lord's Prayer or something?
No, we can do that. I was going to ask Mr. Chandler, how does Pafburn create opportunities for innovation and things like that sort of things?
If it does. Look, I think Pafburn, as I said, is the surround sound. I think the DVP Act is an important part, just like I think the RAB Act is another part of the surround sound. I think the DVP Act is really what we're talking about. Give it a few more years, and it's going to start to tidy that up. At the moment you start to get competent teams, I could run a list of builders off now, I can't remember all their names, but I've been to their offices and I've seen that they've recreated a capability that they've never had before. I sat in January on a startup back to the year for a major builder. And they invited me in and they said, what's and all, we want you to hear what this is all about. So the MD got up and he said, look, he said, what we've decided to do is that we've now got an ISET rating and our projects are going to get a 10-year warranty insurance going forward. And what that's caused us to do is to have a look at what the cost of defects is to our company. And we just looked at it and said, we have spent millions and millions of dollars going back and fixing defects. And so what we've now decided to do as a company is that we're going to treat the provisioning for defects in our historical buildings as a balance sheet item. And he said to his staff, he said, so I've now taken all the jobs we built before 2022, and I've got a provision for them, and I've got a provision for all the jobs since 2022, and I can tell you, since 2022, I've got a 1/5 provision for what I had pre-2022. So as people start to work out the fact that if they're starting to see the trailing impact of defects as a balance sheet item, which a proper company would do, then they're going to be able to face into innovations, Richard, in a way that sort of says, well, let's look at that. We were just talking about prefab over here. You look at prefab and you'll start to say, well, is that going to impact my balance sheet provision for defects and liability? And you're going to be very cautious. So I feel as though the precautionary principle is going to start to apply as opposed to the reckless principle. And I think that's where we should live.
In terms of positives to come out of this Act, it's very positive for owners in the sense that they have increased rights. Whether they're going to get pulled into long and expensive litigation with a disappointment at the end is another thing to be seen. But in terms of how one can make positives out of this, I mean, one positive is it's a wake-up call to people to think about whether they can do things better, and they've been letting things slide too long. Another thing about it is, in management theory, not necessarily reality, but in management theory, focusing on who are your good customers and who are your good suppliers is very important. And I think that makes common sense. And what it says is your best customers, for example, are not necessarily the biggest or the ones with the most work or the ones with the flashiest logo. They are, for example, the ones that don't give you stress, the ones that are not high maintenance to handle, the ones that pay you on time, the ones that don't quibble your bills unfairly. And the positive here is it's giving everybody an incentive to make sure that the people they're dealing with are good customers, are good suppliers. And even if that reduces your turnover, it may improve your profitability. One, because you're dealing with a better class of customer and supplier, and two, you're avoiding the drain that comes down the track when you get called back for defects. And remember, unlike Section 48.0 in the Home Building Act, which says something along the lines of if you've breached a warranty, the tribunal should be looking at trying to allow the builder to come in and fix it if, as a preferred outcome, if it can. There's no equivalent of that in the Design and Building Practitioners Act. So don't sort of sit there thinking, well, if I do this wrong, I'll get a chance to fix it. Some owner or some owners corp or some lawyer may see a lottery win by suing you and going for the big dollars rather than letting you in to fix it at wholesale prices. So if there's a positive out of it, I think you can see there's an opportunity to improve the way you do business, and maybe your cash flow or your turnover will reduce, but maybe in the long run it will improve. That's the hope, that's the positive aspiration of this legislation. Whether in reality it will be the same outcome for everybody, I suspect not, but good management, if you can get good customers, if you can get good suppliers, you'll be better off in the end because you won't have a debt that you can't enforce against some Phoenix company, and then you go broke, and all those people who depend on you as your employees, they're out of work. And if you're a developer and you're hiring a better quality of service from your subcontractors and your contractors, well then you're hopefully less likely to be dragged into court unless some unscrupulous owner decides to drag you there. And then you've got less cost going up in the future with this drain of litigation and defects that you're perhaps just as responsible for as the builder.
Just one short thing I'd like to say. I think you all know my view on Pafburn, which I think is very positive. It's going to force builders to start doing things properly, which is a good thing. Well, the question about insolvency was an interesting one. I was thinking about it. Well, everyone was thinking about the developer-builder. I'm thinking about the builder-subcontractor relationship. What happens if the subcontractor goes insolvent? Where does that leave the builder? So I started molding in my mind what can a builder do to protect himself against the subcontractor going insolvent, going broke. Well, this legislation is going to be around, it's around for a while, at least 10 years, up to 15. Someone's financial position might be fine at the time of doing the contract, so what's their financial position 6 years down the track, where it may come back to bite you? And I started thinking, well, there's issues such as, do you start writing into contracts to subcontractors that you see their financial records at a regular period? I don't know, but I'm just saying these are the thought process. If you want to manage that risk, that if I've engaged a subcontractor, he may not be here in 10 years' time. How do I manage that risk? Because if it goes down, I'm gone. What I can see, what's really interesting with the subcontractors is perhaps there may be a shift in the builders, and I haven't seen this yet. Pafburn is fairly new. Some builders may start shifting the retentions with subcontractors, wanting the subcontractors to put more skin in the game to make sure that they carry out their work properly, and they might hang on to the retentions longer than what they used to. So these are all things that might be on the horizon, because as a builder, again, I look at it from that point of view. If I'm going to be hit with a Pafburn issue 8 years down the track, how do I try and minimise my risk to make sure that my subcontractors are there? Because now I can no longer apportion the liability. I'm in. So I've got to protect myself financially.
I know we're all speaking from our bigger residential and our bigger builders, but have we thought about the smaller residential builders who may only build 1 or 2 buildings a year? If these smaller residential builders really have 2 projects a year and getting slammed their subcontractors' costs, we're going to see them go under very quickly. I don't think the Act has thought of that yet.
Somebody provide a very short answer, because there's some drinks outside waiting.
I think the answer is this, and that is that once you could come into this industry with a mobile phone, a unit and a $2 company, you can't do that anymore. You're building houses now that are $500,000, $1 million houses, you're really fiddling with people's lives. So you've got to be a fit for purpose enterprise. So you're going to have a bit more capital backing to just take on the workload you're doing. So I think the first thing I do is to get people to realise if you haven't got appropriate entry into this industry, you've got to have proper capital, you're going to have proper capability and proper systems.
And I think proper education before you get enter.
But continuing education.
Definitely, but even before you enter.
Not at that university out west.
Very
In terms of the management issue, this is sort of what I was talking about in terms of vetting your suppliers. It gives you an incentive to cut out the people who are going to cause you stress down the track. The problem is you'll get people saying, well, but I just can't find anybody, there's not enough people around, what am I going to do? But this is why this is such a complex issue, and it's not as simple as saying here's a piece of legislation, but you'll be better off if you're rid of bad subbies, if you can find the good subbies. And in that sense, the Act is incentivising people to get people in who will do the right job. In terms of putting in retentions, that's a great idea for the developer, it's a great idea for the head builder. It's not such a great idea for the subby, particularly the kind of subby who might be the equivalent of what Gretel was talking about with the small builder. And they might just not have the ability to pay it. And they may be perfectly great at trades, they may do a fantastic job, and they just can't do it. They can't have that money locked up for that long. And that's going to force a lot of good people out.
Thank you all. I hand you over to Mr. David Tomasis for a short note of thanks, and then there's going to be drinks outside. Thank you.
Well, thank you so much for a really good evening. I know we've gone over time, but I think it's been really worthwhile to hear the various perspectives, and we have been stimulated a lot to think through things more deeply than I think we've been accustomed to. I want to thank our guest speakers, David Chandler, David Weinberger, Tony DiFrancesco, and George Sakos, for your very thoughtful and insightful input. You have certainly stimulated us to think in a very different way, and particularly to rethink what the DPPA and post-Pafburn world means for our businesses in the construction industry. So thank you so much for your contributions tonight. And perhaps we just express our point. And also for Richard for moderating tonight, and for your thoughtful framing throughout the evening. I wanted to acknowledge particularly the Chrysler team for their tireless efforts in curating this event. There's been many hours spent in actually framing tonight's session, coordinating the logistics, ensuring that tonight was not just informative, but seamless and impactful and relevant. It's a testament to the culture of our firm, where we aim to build values of excellence, insight, and genuine connection with our clients and with industry. This is at the end of the conversation, so please stay for drinks. We invite you to stay a little bit longer, enjoy some refreshments, and continue the discussion informally. The networking session is open, and we encourage you to connect with our speakers, panelists, and your peers. In addition, we've also prepared a range of post-event resources, as I mentioned, and you can actually access those resources on the QR code that's in your compendium. Please access that. You will also be able to share in the presentations, the videos, the clips from the videos, and also the presentations will be uploaded in due course, and we'll let you know. Simply scan the QR code. Please also watch out for some future events as we publish those. Thank you again for joining us and for being part of such a great evening, and thank you for your contribution.